Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and the United States Supreme Court. And we are here today to discuss the troubles of Mr. Robert Hunter Biden, a young, wayward youth of 53 who has seen some trouble in his formative years. And he is on trial for various misdeeds and was supposed to enter a plea deal. But that didn't seem to happen because the judge had questions that didn't have answers. And we've heard reporting about this, of course, to be sure, about what did or did not happen exactly. But, nothing is better than the primary source material. So let's do that. Let's not cover the news. Let's cover the primary source material and see what's actually happening here. Now, the way that this typically goes, by the way, is when you're entering a plea, the judge needs to make sure that you are doing so knowingly, intelligently, and voluntarily, so that you know what you're doing it, you've been informed, and that you are making the decision because you want to, not because of external pressures from other people or threats or whatever, right? This is a decision that you've entered into, and you understand what it is, that you understand the deal, and you're doing it because you understand what's going on. So knowing, intelligent, and voluntary. We have seen this, by the way, before in person or by watching it on tape. We've seen this in plea deals. We saw it, for example, in the trial with Fauci in Florida. The guy who killed his classmate, Fucci, I think his name is. Well, not Fauci. Fauci's a different guy. Fucci. Who we saw that as a plea deal, right? We saw that plea conference. It's the standard conference that they typically go to. And the judge will ask basically the same questions. Have you been informed? Do you understand this? Have you read it? Are you doing it because you are guilty? Have you been, coerced, pressured? Are you doing this because you understand? Have you spoken to an attorney? Do you need more time? Kind of the normal routine that you see. And the judges ask these questions in varying degrees, in varying forms, but all to the same substance. So this obviously went a little bit more off the rails because it is 92 pages. This should not take 92 pages. So something else other than that happened. So we're going to see exactly what happened as we read this. In the case of United States of America versus Robert Hunter Biden on July the 26th. Okay. Let's cover some more. The court. All right. Good morning, everyone. Please be seated. All right. Hold on. Let me just start by reminding everyone there's no recording of these proceedings that's permitted. For those of you in the back, you're certainly welcome to watch, but will not have any disruption. Any disruption or attempt to disrupt will result in court personnel or United States Marshals escorting you out. All right with that. Mr. Wise. Good morning, Your Honor. Leo Wise, Derek Hines, and Benjamin Wallace on behalf of the United States. Now is the time for the court has set for an initial appearance on a criminal information filed in the United States versus Robert Hunter Biden, charging the defendant with a firearms offense and for entry of a guilty plea to a criminal information filed in a separate matter, United States versus Biden, charging the defendant with 2 counts of failure to pay taxes. So this plea deal resolves 2 different cases, is what they're saying. The parties are ready to proceed. I ask permission to pass up an executed version of the plea agreement in the tax case at this time. You may. Thank you. And my understanding, Your Honor, is Your Honor will first conduct the initial appearance on firearm charge and then turn to the plea hearing on the tax charge. No, hold on. Let me just take a look. All right. Good morning, Mr. Clark, Mr. Biden. Mr. Clark says, good morning. The court. Just so we don't have you feeling that you need to pop up and pop down, I'm fine if you want to, while I'm asking questions, stay seated so you don't have to keep popping up. We won't do it at any other time. All right, thank you. So we do have 2 cases here. One is a criminal action based on a felony information relating to a gun charge. And the other is a criminal action based on a misdemeanor involving a tax charge. This is the defendant's first appearance, the first time they've appeared in court. I plan to conduct the initial appearances on 2 cases at the same time. Is there any objection? So they were initially going to do them one by one, but the judge says I want to do them both at the same time. So rather than he wants to just consolidate them, as opposed to doing the same thing twice. So they say, no, there's answers. I thought it might be efficient and save time. Fair enough. We got all the parties here. We don't need to step through the entire process twice. We can do it once. That makes sense. Mr. Biden, in the criminal action, the United States Attorney for the District of Delaware has filed a felony information which charges you with possession of a firearm by a person who is an unlawful user of or addicted to a controlled substances in violation of United States law. And in the criminal action, the United States Attorney for the District of Delaware has filed a misdemeanor information which charges you with 2 counts of willful failure to pay tax in violation of law. Do you understand these are the charges that are pending? Yes, Your Honor. Do you understand the maximum penalties for the gun charge are 10 years of imprisonment, a fine of $250,000, 3 years of supervised release, and special assessment of $100? Yes, Your Honor. This is valuable. You need to do this, right? Because you need to understand, the person needs to understand the maximum penalty that's theoretically possible. Because depending on the nature of the plea deal may not bind the court. So the deal is between the parties. So the court can say, yes, I accept your plea. And also the recommendation is interesting and all, but I'm going to do something else. That's at least possible some of the time. So the court has an obligation to say, okay, here's the maximum possible you could be facing. You probably won't, but you could, so that you're aware. Defense says, yes, Your Honor. And you understand the maximum penalties for count 1 and 2 of the tax case are 12 months of imprisonment, a $100,000 fine, or twice the gross gain or loss of the offense, which is ever greater, 1 year supervised release, restitution, and $25 special assessment. I don't know why they come up with these numbers. Like, also throw in $25. All right, now, Mr. Biden, you have the right to be represented by an attorney in these matters. It means if you can't afford to, you can hire an attorney of your choice. If you can't afford to, you may ask the court to appoint a representative. Do you understand that? So, giving him basically his rights. Yes, Your Honor. All right, you're presently representing Mr. Clark. Do you wish to continue that? Yes, Your Honor. All right, now, Mr. Biden, you have the right to a preliminary hearing in this case. At the hearing, the government would have to produce sufficient evidence to show you probable cause to believe that the crimes you've been charged with is available. At that hearing, you could have the right to introduce evidence and cross-examine witnesses. Do you understand that? So yeah, preliminary hearing is pretty typical. Defense lawyers sort of vary on this and sort of whether they like them or not. I think the general consensus, such as I'm able to divine such things, is most defense attorneys don't do them, but some really like them. Even if they don't ask literally a single question during the hearing, just to be able to hear what the state has and sort of get like testimony on the record. So some attorneys like them, even if they literally will not ask a single question during the preliminary hearing, just to be able to sort of get the witnesses on the record, just to be able to hear the theory of the case, just to be able to hear what the other sides, how they do things and how they question things, sort of tease out what their theory of the case be, right? So as a pure information gathering exercise, some attorneys will do it. So it's like, we're going to sit there like a log and say nothing, but we're still going to make them do it because maybe we'll learn something. So that's an option too. So anyways, that's what they're talking about. At the hearing, you have the right to introduce witness and cross-examine adverse witnesses. Do you understand that? Yes, Your Honor. All right, now I understand that you intend to plead guilty to tax charges. Do I have that right? Yes. All right, do you understand that if you plead guilty, you're waiving your right to a preliminary hearing? So this is part of that knowing, intelligent, voluntary thing. Do you know what you're doing? So the court is literally going to inform you. How do we know that you know? How do we know that you know? The court will tell you right now. This is how we prove knowing, right? I will tell you. This is what you're doing. So now you know. I also understand there's a plan for the gun charge is a diversion agreement. Counsel, do we need to do anything regarding a preliminary hearing at this point in light of that agreement? No, Your Honor. We're in agreement with that. So they say there's no need for the reading of rights because this is going to take it outside of the judicial process. So there's no need for that. Okay. The court says, all right, Mr. Biden, you're not required to make any statements to authorities. If you already made statements to authorities, you can stop and not make any more. If you start to make a statement and change your mind, you can stop. Any statement you can be used against you. Do you understand? That sounds suspiciously like Miranda because it is. All right, now pursuant to Due Process Act, I confirm the government has a continuing obligation pursuant to Brady v. Maryland and its progeny to produce all exculpatory evidence, and I order it do so at the appropriate time. The consequences for violating the obligation and or my order could include, but are not limited to, contempt, sanctions, referral to disciplinary counsel, adverse jury instructions, exclusion of evidence, and dismissal. Does the government understand that? Yes, Your Honor. So yes, the government has an obligation to turn over evidence, both because of Brady and the statutes that Congress passed Brady, and now the court is also going to add an order on top of it, just in case they didn't get the memo. So you have an obligation to turn over the evidence to the defendant, which you should know this already. Brady's only been the law for the last 60 years, but some of them don't seem to have gotten the memo yet. Has all Brady material been produced? Yes, Your Honor. Which isn't necessarily true, incidentally, at this stage. It may be true, but it may not be true, depending on what the deal is and determining what the plea is. And again, this just goes to knowing that you know it. So if the government has not turned over Brady, they may not have an obligation to at this point. It all depends on the timeline. It all depends on when this is happening, sort of in relative to the case. So at this stage of the proceedings, probably not required. But if this plea deal were happening at a later stage of the case, it may have already been required. So the answer to this question might be no, we haven't turned over that. No might be an acceptable answer at this point. But the court wants you to know the answer is no. So they know, so that you know that you are waiving it in the dark, that you know that you're doing that. So the court, but they say yes in this situation. They ask any concerns? None whatsoever. So the defense doesn't have any concerns about that, apparently. Pretrial release. What is the government's position? So what do you recommend before we do trial? What kind of bond or bail? The conditions that have been recommended, we agree with. Any concerns? No, we're in accordance. You can't help yourself. You're just going to keep jumping in. I was taught at a hard school. I know. I couldn't even think if I was standing. Oh, he just keeps standing up every time. I was wondering what they meant by that. He meant literally jumping up. I was confused for a second. He meant literally jumping up. So the attorneys, the court said to him, you don't need to stand every time, but he is standing every time, which, reflexive habit. So fair enough. I thought he meant jumping up like metaphorically initially. I thought it meant like he was speaking out of turn or something. That's why I was confused. Anyways, I understand that this is a pretrial release. I agree that the pretrial release is appropriate, subject to the following conditions, which I'll read into the record. Defendant must not violate federal, state, or local law while on release. Defendant must cooperate in the collection of a DNA sample if authorized by law, which I don't believe it is in this circumstance, but, just reading off the standard stuff. The defendant must advise the court or pretrial service officer or some supervisor in writing before making any change in residence or telephone number. Defendant must appear in court as required, and if convicted, must surrender it as directed to serve a sentence that the court may impose. And then they follow additional conditions. You must submit to supervision by and report to supervision to a probation office in the district in which you're residing. You must continue or actively seek employment. You must communicate in writing all international travel plans and provide supporting documentation, if requested, to both the District of Delaware and the district in which you're residing. You must not possess a firearm, destructive device, or other weapon. You must not use alcohol. You must not use or unlawfully possess a narcotic drug or other controlled substance as defined by law, unless prescribed by a licensed medical practitioner. I'll clarify, however, that marijuana is not legal under federal law, and you're prohibited from using marijuana regardless of whether it's legal or not in the state in which you're prescribed. So, of course, because this is federal court, the court is going to insist that you follow federal law, which makes marijuana illegal. So you can't use it regardless of state law, which, fair enough. You must submit to testing for a prohibited substance if required by pretrial services. Testing may be done with random frequency and may include urine testing, the wearing of a sweat patch, remote alcohol testing system, and or any form of prohibited substance screening or testing. You must not obstruct, attempt to obstruct, or tamper with the accuracy of the testing. So, they might do a drug test on you and you have to comply. You must participate in a program of inpatient or outpatient substance abuse therapy or counseling if directed to do so. So I'll leave that for them, but if they tell you to do it, it is not optional. Do you understand that? Yes. All right. Any objection or comment? None from the defense, not from the United States. The court. All right. Mr. Biden, violating any of the conditions of release may result in immediate issuance of warrants for your arrest, revocation of release, order for detention, forfeiture of bond, or prosecution for contempt, and can result in imprisonment, fine, or both. Do you understand that? This is pretty standard, right? You violate your bail conditions, and you can get arrested for it. And also the bail itself will be extinguished. And it also leads to a new charge unto its own right, bail jumping. Anything I left out or anything you need to address? Not from the United States, not from the defense. So far, pretty standard. Now we have 2 cases and 2 agreements, and I understand the diversion agreement is not something typically before the court, but y'all did send it to me, so I want to talk about that a little bit. There are some provisions in these agreements that are not standard and different from what I normally see, so I think we need to walk through the documents and get some understanding of what's being proposed so I can give due consideration and determination you're all asking me to make. So we want to start with the criminal action involving the charges. So the court is saying that, this diversion agreement is not something we would normally see in the court because it's just an agreement between you and the government. It's a non-prosecution agreement, which doesn't need to be approved by the court. But for whatever reason, they sent them a copy. I'm not sure why they did that, but there's I'm not normally seeing these things, but you guys sent me a copy and I have questions. So, okay. Perhaps because the case was related, I'm not exactly sure what that is. I'm not an expert in the criminal procedure aspect of that, about why they did it. Maybe they were obligated to under this circumstance. So anyways, I want to start with a criminal action involving the tax charges. All right, now, Mr. Biden, you told me that you intend to plead guilty. Yes, Your Honor. So it's my responsibility to make sure the plea is voluntarily and knowing. In order to do that, I need to make a series of questions. Before I ask you these questions, I'm going to place you under oath to answer those questions truthfully. And it's important that you answer the questions truthfully because if you don't, any false answers may be used against you in a separate prosecution for perjury. Okay, do you understand that? Yes. So he takes the oath. All right. Thank you, sir. You may be seated. All right. Now, sir, if any time you want to confer with counsel when I'm asking a question, you may. Just let me know. Thank you, Your Honor. How old are you? 53-year-old, Your Honor. How far did you go in school? Law school, Your Honor. When did you graduate from law school? 1996. You a member of the bar? Yes, Your Honor. Any particular? District of Columbia and Connecticut, Your Honor. Thank you. And you speak and understand English? Yes, Your Honor. Are you currently or have you been under the care of a physician or psychiatrist? No. Have you ever been hospitalized or treated for any mental illness or addiction to a narcotic drug of any kind? I've attended treatment facilities for addiction, Your Honor. Okay. So that was included in my question, which is a treatment for addiction to drugs. Yes, Your Honor. So I need you to tell me about that. How many times have you, to the best of your recollection, been treated, whether inpatient or outpatient? Beginning in 2003 with the inpatient, Your Honor, I believe to have been close to 6 inpatient over the course of 20 years. I guess the inpatient therapy isn't going super duper well. And I've also been in outpatient programs during that time. His lawyer says, just to be clear, it's numerous, Your Honor. So apparently it's too many to count. Exciting. I'm not going to walk through every single one, but I just want to make sure I have some understanding. Now, sir, each time you were treated inpatient, what was it for? For addiction to alcohol, primarily originally, Your Honor. Okay, and have you ever been in an inpatient program where you're treated for something else other than alcoholism? Drugs also, Your Honor. Okay, and I'm just not sure how these programs work. I'm sorry. Is it for any particular drug you've been treated, or is it just sort of for no, everything, Your Honor. So the court, I'm sure, is familiar with how drug treatment programs work in general, but not necessarily sure how the programs he's been seeing work. So he wants a little bit of clarity on that. Okay, when was the most recent time you were in treatment? Well, are you currently in treatment for alcohol? No, I'm not. When was the last time you were in treatment? I believe the fall of 2018. The attorney says, I think that's right. Okay. Your Honor, sorry. That's okay. So the fall of 2018. And was that inpatient or outpatient? Inpatient and then also outpatient. Okay, and did you complete the program or did you leave the program prior to completion? I completed that program, the inpatient portion of it, Your Honor. Okay, and after you completed the program, did you then continue to use drugs for some period of time? I did, Your Honor. Again, the drug treatment facility seems to be less than fully successful. All right, so when was the last time So fall of 2018 was the last time you received any treatment? Yes, Your Honor. So he hasn't received any treatment for 5 years? Okay. When was the last time you used, ingested, or under the influence of any drug, legal or illegal, or alcoholic beverage of any kind? June of 2019. Really? You're telling me that for 4 years you haven't had a drink? Okay. All right. All right. And just to be clear, you're not presently under the influence of any drug, legal or illegal, medication, or alcoholic beverage of any kind. Is that correct? No, Your Honor. Let's just be clear because, people might look at the transcript. We're looking at the transcript. I just said, is that correct? And you said no. I'm sorry. Yes, Your Honor. Excuse me. And, sir, do you understand what's going on and why we're here today? Yes, I do understand. Counsel, do you have any doubts as to your client's competence? None whatsoever. In the legal sense of the term competence, sure. Any concerns from the government? No, Your Honor. Based on the information that I've received, Mr. Biden, I find you're competent and capable of proceeding, which is what all these questions were devoted to, right? Are you sane? In other words, are you competent to participate? So the judge finds competence, which is to be expected, but the judge still has to ask the questions. So, because, it's like, I'm high on drugs right now. I had cocaine this morning. I got a little bit of blow in my suit. You want some? These are information that might preclude the defendant from participating at that particular moment. So now I want to talk about, misdemeanor information which contains tax charges that you're pleading guilty to. Have you received a copy of the information pending? Yes, Your Honor. Have you discussed it with your attorney? Yes. Are you fully satisfied that counsel, representation, and any advice you receive from him in this case? Yes, Your Honor. You have the right to have this information read out loud at the hearing, but you can also waive it. Would you like me to ask the government to read it or waive it? Waive it. Yeah, I don't know many attorneys that will ask it to be read because why? It just takes time and it's kind of annoying. Like, you have the right to have the charges formally read out by the court, but why? Like, you can read them on your own time. I can tell you about them later. Do we really have to sit here and have the charges read? No. So I don't really know any attorneys who want it read because why? There's no point. Okay. Next, the memorandum of plea agreement, which handed up to me. First, let me ask counsel, what provision of the rules is this plea agreement? This is important because different kinds of plea agreements come under different kinds of rules. And as I sort of alluded to, there is even a plea agreement type that can bind the court, which is not typical in the state system. I'm not aware of that being true of anywhere in the state systems, incidentally, but then again, there are lots of states, so I don't know. But typically, a plea agreement is between the parties. It does not bind the court. What is binding is the recommendation. What the court does is on their own time. Sentencing is for the judge. But there is a type of plea agreement that does bind the court. The court doesn't have to accept it, incidentally. So the court can still say, no, I'm not accepting the plea. But if they accept the plea, the recommendation is binding on the court. So there is a type of plea that's available for that. And there are other kinds of pleas. So, like, what kind of plea is this? So they say it's presented under Rule 11C1B of the Federal Rules of Criminal Procedure. And all right, just so we're clear, you agree? I do. And then they say, they get to the point that I just said. Just so we're clear, this is not a plea under Rule 11C1C, which often called a C plea, which binds me. See, it's nice when I get there before the court. Then you guys know that I'm not just making shit up. It's always validating. It's nice when I say something, and then two sentences later, the court says the same thing. It's like, oh yeah, there's a kind of plea that binds the court. This is not exactly common in the state system. I've never heard of it in the state system, but it does exist in the federal system. And then the court says, okay, this isn't that, is it? Yeah. So this is in the C plea, which would bind me. Is that correct? Right. We agree. So in your view, what is my role here? Great. Your Honor has two roles, as Your Honor has already begun to determine plea is knowing and voluntary, and to apprise the defendant you're not bound by the recommendation. So, again, right, this is not binding on the court. So the recommendation is the recommendation. The court could do something different. But, so it's like, okay, so you do understand, which is one of the reasons also they read the maximum penalties earlier. Because, like, hypothetically, the court could impose anything. You don't know, because you don't have any promises with me. So we're not bound by the recommendation. That's it. That's it. All right. Now, is it my role to accept or reject this plea? It's not, Your Honor. Well, and the court, and he says no. Why? The court can reject a plea, I would imagine. But okay. The court could reject the plea as not in the interest of justice, I would imagine. But they're saying the judge has to accept the plea? Okay. I don't know about that one. Now, just let me ask you this. Would my role be different if it were a plea under Rule A? Yes, it would. How would you say it's different? Both Rule A pleas and Rule C pleas require the court to either accept, reject, or defer on the agreement itself, not on the plea, which is governed by, as I say, a separate provision of Rule B. But it's the court's rule vis-a-vis the agreement is to accept, reject, or defer. All right. I want to talk about that a little bit further. When we talk about the plea, you can sit down for now. Now, let me ask you this. If there's a plea, what is your understanding of the factors I need to look into? So the rule itself is silent on the factors, but the case law suggests the factors that rejecting or accepting the plea would relate to the court's traditional role in sentencing. So if, for instance, the court thought that the charge bargain, which is what A does, if the court thought the charge bargain did not adequately reflect the seriousness of the offense, which would affect the ability of the court to sentence, then there's case law that says they could reject it. Yeah, that sounds right, right? This deal is too generous. This deal is too generous, so I'm not going to do this, right? You have negotiated this brutal murder down to a traffic ticket. Like, no, I'm not doing that, right? So it is unusual, but it does happen every once in a while. It does happen every once in a while where a court gets really, really pissed and the prosecution makes a deal that's too sweetheart. Every once in a while, a judge will go be like, how about nah? Because it's not in the interest of justice. Screw you. I'm not doing this. You can't make me. So it does happen occasionally. Okay. The court says, when you say charge bargain, you mean the bargain by which defendant pleads guilty and the government agrees not to bring other charges or drop charges. Yeah, exactly. So I'm not sure what they mean by charge bargain either. We can just call it the bargain because whatever it is, right? The bargain is the bargain. What am I getting? What are you giving? So basically, this is unconscionability for criminal pleas. That's basically what this is, right? So in a civil, and I mean, plea agreements are thought of in terms of contract, and you'll see that language used in the case law all the time. Plea agreements are contracts. They're a special kind of contracts, right? So the idea of unconscionability in contract law is that there are agreements that are so batshit that the law will not recognize them. You guys may have agreed to this, but how about no? How about this is just fundamentally unfair, and we're not going to do this? So same idea, right? It's basically unconscionability is what they're saying. This agreement is so bad in the criminal context that the court just says this is unconscionable. So how about I say no? Okay. And looking at an A plea, what I need to consider are those factors you just also about is usually referred to as the interest of justice. They are, Your Honor. That's correct. The interest of justice. I might have used that language already. Exactly that language. The interest of justice. All right, you can be seated. So yesterday I received from third parties a letter, which is almost 900 pages of attachment in one case, a memorandum of law with hundreds of more pages of exhibits in others. I have not time to review those submissions. I understand there's some objection to them. I'll give the government and defendant the wish to respond if they choose. But even though I've not been able to review the third-party submissions, I do understand that they request I reject the plea agreement based on information that the filers submit cast out on the investigation performed. So amicus briefs, which is what this is, a third-party submission, are a little atypical, in fact, extremely atypical in a trial level. They're not unheard of, but they're rare. They're very rare. And they do have to be filed with the permission of the court. So some people have asked, essentially, for their amici to be put on the docket, but, without permission of the court, or the parties or, whatever, the court can be like, nah, and strike them from the record. So, and also the court doesn't have to look at them in any event because they're there to be a tool for the court. So the court can look at them or not as they please. They are not submissions by the parties. They don't have a right to be heard. So anyways, there's something on the record that I haven't looked at, which I don't have to look at, but So let me ask you this. If I were to think that the facts presented in those submissions were in the facts that have been presented to me in this case, and the attached agreement suggest the investigation was lacking or that more serious charges should have been brought, is it within my power to ask or direct the United States Attorney or Attorney General to redo the investigation or bring more different charges? We don't believe so, Your Honor. We agree, Your Honor, it would raise obvious massive separation of powers questions if that was to be taken. Which, fair answer. The decision as to what to prosecute is a decision for the government, and the decision was for the executive branch. So I think this answer is right. The decision about what to investigate or not is a decision to the executive branch. The decision what to prosecute or not is a decision to the executive branch. And when to bring charges as part of that investigation, if any, and any charges is up to the executive. Because think about this logically, right? It is probably true in the overwhelming majority of cases, if not all cases, that there is no absolute endpoint for an investigation. An investigation could go on theoretically indefinitely because there's always questions to be asked. At some point, you just stop because every material question has been answered. But you could keep digging, but you don't, right? At some point, you just stop. And so, okay, well, when in that process is it too early for the government to bring charges? And the answer to that question is, well, if they have it, they have it, right? So if, on day one of the investigation, they get enough information to convict you, well, that just turned out to be a really good day for the government, I guess. How nice. Everything that we need just came together in a nice bow package. How convenient. We could keep looking, but why? Or, whatever the case is. So could we look further? Sure. But we have enough and we're ready to go. So they're probably right. Okay. And isn't the decision about what charges to bring for the prosecutor part of the executive branch? It is. We concur. Correct. All right. So if there were a failure in the investigation or charges brought were inappropriate, how would we get that addressed? Through the political process. That's probably correct. In particular, Your Honor, the executive branch is charged with investigating, making prosecutorial discretion decisions. Indeed, that's where the term prosecutorial discretion comes from. It's vested in the executive branch. That sounds like the correct answer. All right, let's walk through some of the provisions of the plea. Do you have it in front of you? Yes. It's 6 pages long and attached Exhibit 1, which is 4 pages long, as well as a sealed attachment referred to as Attachment A. Attachment A is a document that is not public, but is a standard document that's filed in all cases in this district and is not filed only in connection with this case. The memorandum of the plea agreement has 3 signatures on the final page. Is one of those signatures yours? The defendant? Yes. Okay, when did you sign it? This morning. And before you signed it, did you have the opportunity to read it and discuss it? I did. Are you satisfied with the advice you received? I am. All right, then let's have a sidebar up here, during which time they discuss something relating to sealed attachment A that is sealed in the transcript. So that is not available at this time, or possibly ever, because it's sealed. So that portion of the transcript is redacted. All right, let's go back on the unsealed portion of the record. So now I'm going to ask the prosecutor to read the essential terms of the plea agreement. So I ask you to listen carefully to what it says, because when it's finished, I'm going to ask you if the agreement as recited by him reflects the deal. This all goes, again, to the knowing, intelligent, voluntarily. Do you know what you're doing? So we are going to read into the record the agreement that you already signed and hopefully read, just to make sure that you know. We don't want you claiming, I didn't know. Oh, no. Okay. So we will read it to you too. Thank you, Your Honor. Paragraph 1 provides that the defendant waives any challenge to the information based on venue. This is the wrong place to bring the court. and agrees to plead guilty in this court for counts 1 and 2 of the information, which charged him with willful failure to pay tax. So we waive the issue about whether this is the right court, but it almost certainly is. So it's kind of a moot issue, but just for the record. Paragraph 2 describes how defendant understands their maximum penalties for each count, as Your Honors previously indicated, which they go into again. And then they say the cost of prosecution is stipulated as 0, which, fair enough. I mean, this is so early in the process that that's a reasonable term. Paragraph 3 describes the essential elements the government would have to prove if the case went to trial. And that 1, the defendant has a duty to pay, 2, that taxes were not paid, and 3, the failure to pay was willful. Defendant knowingly and voluntarily and intelligently admits his guilt to each of the elements, and further admits to the information contained in the statement of facts which is attached. So here's what we'd have to prove. Here is our evidence. He agrees to that. Paragraph 4 provides defendant is pleading guilty because he is in fact guilty. Pretty standard. Paragraph 5 contains certain stipulations under sentencing guidelines. 5A provides that the amount of loss is whatever the amount is, which goes to the sentencing guidelines. So there's a maximum statutory range, and then there's a guidelines recommendation range. And so it stipulates to the amount of damage, which stipulates to the guidelines range. Paragraph B provides that the conduct set forth in the statement of facts to the diversion agreement filed, which will be filed today, does not constitute relevant conduct pursuant to United States sentencing guidelines. Paragraph C provides the United States does not subsequently learn of conduct by the defendant inconsistent with the acceptance that will not oppose a 2-level decrease. This is also very standard, right? So by agreeing and pleading early, you get a downward departure in your sentencing. 2 levels is standard. So it's like, well, as long as, we don't learn anything that is inconsistent, he gets a bonus for cooperating. Pretty standard. And further, should it be determined that offense level 16 or greater prior to application of the 2-level reduction, that the United States will move to reduce the sentence, the guideline by 1 additional level pursuant to law for a total reduction of 3 levels. Fair. This is very standard. Nothing suspicious yet. This is very standard. It's understood and agreed by the parties that stipulations are not binding by either probation or the court. So even though we agree on the amount, if for some reason the court can come up with a different number, then the court can use a different number, which seems unlikely, but stranger things have happened. So here's what we agree the number is, but maybe your court has a different calculation. So, yeah. Second, the court may make factual and legal determinations that differ from these stipulations. As I just indicated, the court can make findings of fact in this situation. It's part of the deal, right? So here's what we agree the facts are. Are those the facts? The court can be like, nah, here's what the facts are. If they can do it, but, in principle. So the court can find facts. And if it does find different facts than we think, this could increase or decrease. It could go either way, right? Someone's wrong, maybe. So it could go either way. So you accept that risk that somehow the court will find something, and you plead guilty. You plead guilty to the offense, which was once again, why they tell you the maximum possible range, right? They tell you the maximum possible range because they already warned you of the maximum possible consequence. So if for some reason the court finds different facts that raise the guideline range, well, too bad for you, because you're still getting exactly what you promised, right? You were promised not to be sentenced to more than this. That was all you were promised. So, congratulations. Paragraph 6 provides that for the reasons to be articulated at time of sentencing, the United States will recommend probation, which again, the court could theoretically ignore. Paragraph 7 provides the United States retains the right to defend the rulings of the district court in any subsequent proceeding, which, would be what you would expect. Paragraph 8 outlines the length of sentencing procedure. Paragraph 9 contains broad appellant waiver, also very typical, that you waive your right to appeal, although once in a while, they'll let you keep your right to appeal, and every once in a while, it's successful too, which is hilarious when it happens, right? Every once in a while, it's like, yeah, you can keep your right to appeal because the government thinks there's no way this appeal can work, and every once in a while it does, which is always kind of fun. I enjoy the Schadenfreude of it. I enjoy the prosecutor being like, "Yeah, you appeal, ha 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 ha," and then they get hoisted on their own petard. It's fun. Paragraph 10 provides the defendant agrees to pay a $50 special assessment. Ooh, it went up from $25. I guess that was $25 for each count. Now that's too much, man. I thought it was only going to be a $25 assessment. Now you're talking about a $50 assessment. I have to pony up $50. I want out of the deal. Paragraph 11 provides the memorandum, especially incorporates attachment A, which is attached and filed under seal. As Your Honor said, routinely file such attachments, even though they may or may not constitute additional terms. To the extent they does, the parties agree to be bound by it. So whatever's in there, also binding. Party 12 agrees restitution in the Mandatory Victims Act. Defendant agrees to an entry of restitution for full amount of losses attributable to the activity, which is expected to be zero because the associated interest and penalties have already been paid. So the government's already been made whole financially, so no more penalty there. However, the defendant understands that an unanticipated amount of restitution will not serve as grounds to withdrawal. So in the unlikely event that for some reason it turns out, the amount of restitution is $50 million, well, too bad. You agree to pay us our loss, which we might be able to determine at a later time. Again, the problem isn't that you don't know, as long as you know that you don't know. This is all about knowing intelligent and voluntary. As long as you know, there's a chance. As long as you know that you don't know, you can plead. So it's like, could it be higher? Theoretically, yes, but you know that. So assumption of risk kind of idea. All right. The parties further agree that should the IRS determine their additional taxes, they're not subject to the terms of this agreement for the purposes of the memorandum. So if for some reason the IRS does another audit or something and they realize, actually you still owe us more tax, they're not bound by this. So in that event that, for some reason it'd be like, banking error found or whatever, the IRS might want more money and you have to pay them more, which you had to do anyway, incidentally. You always have to pay your tax, even if the government screws it up. So if that happens, then you agree to pay what additional taxes are owed. Probably won't, but just in case. A lot of this is probably won't happen, but just in case. And finally, paragraph 13 provides it's further agreed by the parties the memorandum and Exhibit A together supersedes all prior promises, representations, and statements of the parties. The memorandum may be only modified in writing, and then any all promises, representations prior to this or after this are null, which is standard contract language. As once again, it's very common to see courts say these are understood like a contract. This is just an integration clause. This is an integration clause in any contract. This is the agreement. This is the only agreement. There are no other agreements. This agreement is complete and forms the total expression of the parties. This is an integration clause. It's a contract. Yeah. So I guess slightly odd, and says that if you want to modify it, it has to be modified in writing. Which, yeah, fine. All right, so the court says, I did have a couple of questions. Paragraph 5A says the amount of loss no less than 1,100. Well, actually, before that, we ask that, I'm going to ask you how it relates to facts. Why don't you go through Exhibit 1 you referenced? Why don't you put Exhibit 1 on the record? Yes, Your Honor. At all times relevant to the instant information, the defendant was an attorney and businessman with lucrative domestic and international business interests. From 2017 to 2019, he served on the board of a Ukrainian energy company and a Chinese private equity fund. He further negotiated and executed contracts for business and legal services that paid millions of dollars in compensation to him and or his domestic corporations, Oswaco PC and Oswaco LLC. Through at least early 2017, he was also employed by a prestigious multinational law firm in the of counsel capacity. That's cute. Of counsel can mean a lot of things, but it also can be a very honorific thing. So being named of counsel suggests a special relationship, and it's usually a more detached relationship. than a normal attorney. So it's being named of counsel suggests that you are employed for a limited purpose or employed for what would you say? That you're employed in other than the capacity of a full-time attorney. It suggests that you have a relationship that's a little bit more distant. It can mean a lot of different things, but it's also sometimes just an honorific, right? It's like, yeah, you are. It can be just kind of an honorific. So the fact that Hunter Biden is of counsel is kind of hilarious because it's probably more in the honorific camp. So yeah. For this work, he earned substantial income, totaling more than $2.3 million in 2017 and $2.1 million in 2018. Biden has a well-documented and long-standing struggle with substance abuse. Following the death of his brother in 2015, Biden relapsed and over time progressed from alcohol to abusing illegal drugs, including crack cocaine in 2016. This contributed to the collapse of his marriage, with divorce finalized in March 2017, as well as the collapse of his most significant professional relationship in fall of 2017. Nonetheless, in 2017, despite addiction, Biden successfully entered into business ventures and landed legal clients earning millions of dollars. Wow. I mean, that's one hell of a recovery, man. I mean, he went from he had death of his brother in 2015. He went to relapse of drugs in 2016. And by 2017, he was already back in business, landing legal clients and earning millions of dollars. Wow. That's a really ashes to riches story in record time. Biden must be a person of exceptional character to be able to do it that fast. I mean, to go from such low depths to such great heights, basically on the turn of a dime, Biden just must be the most resilient, hardworking character ever, a model to us all. Or perhaps there's another explanation. Okay. By his own telling in a memoir published in 2021, Biden's substance abuse worried in 2018. So he's landing clients earning millions of dollars while high on drugs. Okay. Okay. A year that included a move to Los Angeles as what's been described as spring and summer of nonstop debauchery. Even during this period, however, Biden continued to earn money and exercise control over personal and corporate finances. Federal income tax returns and payments are due on or about April 15th of every year. Biden, like other taxpayers, routinely requests an extension, pushing due date to October 15th. An extension of that time does not extend the payment for taxes, which remain due in April. During calendar year 2017, Biden earned substantial income, including just under $1 million from a company he formed with the CEO of a Chinese business conglomerate, $666,666 from his domestic business interests, $664,000 from a Chinese infrastructure investment company, $500,000 in director's fees from a Ukrainian energy company, $70,000 relating to a Romanian business, and $48,000 from a multinational law firm. Okay. Throughout the tax year, Biden worked with a DC and Maryland-based accountant to prepare his individual and corporate tax returns. In 2018, this accountant, who died in 2019, and you can make your own Hillary Clinton joke at this point if you like, prepared Biden's 2017 corporate and individual tax returns. Through the fall, repeatedly attempted to provide them to Biden for review and signatures. These efforts included directly contacting Biden, reaching out to his administrative assistants, and sending copies to his former business partner. The former business partner reviewed the returns and sent emails to Biden in which he commented on their substance, reminded Biden of the following obligations. The former business partner left for the final returns for Biden at Biden's office. Despite these actions, he neither signed nor submitted the returns. Okay. Not only did the accountant timely prepare Biden's individual and corporate tax returns, the accountant repeatedly encouraged Biden to timely pay taxes associated with returns, beginning in April 2018 and continuing into April 2018. The accountant advised Biden to make his own tax payments, noting approximately $600,000 owed by Biden personally and $204,000 owned by Wasco PC. Biden told the accountant he could pay $25,000 in April towards his taxes, but no such payment was made. Is he having trouble coming up with the money? Where is it all going, Hunter? His large tax liability stemmed from the fact that over the course of 2017, Biden began withdrawing substantial funds outside of Ayahuasca's established payroll system, which had been created, in part, to ensure that Biden had sufficient withholdings to timely pay outstanding tax liability. Yeah, that's not good practice. He's withdrawing corporate money to pay a personal debt. That's bad practice. You shouldn't do that. Yeah. The end of the year liability should not have come as a surprise. At times of withdrawal, Biden's business partner advised him that these transfers, made without withholding, would result in significant liability at the end of the year. Despite the large outstanding tax liability and profligate spending, on or about April 17, 2018, the due date for the payments, Biden did in fact have the funds available to pay the liability for his return. So he had the money on hand. On or about March 22nd, 2018, Biden received $1 million payment into his bank account as a payment for legal fees for Patrick Ho, and $939,000 remained available as of tax day. Over the next 6 months, Biden would spend almost the entirety of this balance on personal expenses, including large cash withdrawals, transfers to a bank account, travel, and entertainment. Biden continued to earn handsomely and spend wildly. He received a little over $2.6 million in business and consulting fees from the company he formed with the CEO of the Chinese business conglomerate and the Ukrainian energy company. However, without the structure of a stable business partner and still in the throes of addiction, Biden essentially ignored his tax obligation, withholding. How is he getting these clients to give him such a huge amounts of money when he is high on drugs out of his mind? He's so high on drugs that he can't pay his taxes, but he can perform his role as a lawyer. How does that work? How's that work? How are you so coked up that you can't be bothered to sign your tax returns, but competent enough to do $1 million worth of legal work? How does that work exactly? However, with the structure of a stable business partner still in the throes of addiction, Biden essentially ignored his obligation, withholding only $38,465, less than 6% of the tax owed. Tax returns and filing for 2018 were due on April 15th, 2019. On that date, Biden traded emails with his accountant and attorney about seeking an extension. The accountant advised Biden of his obligation to make the tax return on that day, irrespective of the extension. Ultimately, the extension was filed, making the return due October 15th, but he paid nothing. Ultimately, the extension was filed, making the return due on October the 15th. I feel like these people are overpaying for Biden's legal services at this point, given his abilities. I feel like the $1 million is overpaying for his legal services. So I'd like to offer my legal services for the low price of $800,000. And I promise to do at least as much as Hunter Biden did for his $1 million. What a deal. 20% discount and you'll get the same quality of service. Guaranteed. Who wouldn't take that deal? Sign up now. I'll even get admitted in Delaware if it makes you feel better. I passed the multi-state. I'll get my license in Delaware. You give me $800,000 and I will give you all the legal services that you're accustomed to. By late May, Biden has spent almost the entire sum on personal expenses, including large cash withdrawals, payments to or on behalf of his children, credit card balances, and car payments for his Porsche. Not for nothing, but does Hunter Biden still have a law license? How does this man still have a law license? After numerous payments and trips to rehab, Biden got sober in May 2019. All right, chat, I want to know who here believes this? Who here believes that Biden, after the 6 inpatient drug treatment centers over the 20 years, plus too many outpatients to count, who believes that after all that, that in May 2019, Biden finally got sober? Anyone believe that? I'm going to go ahead and press X to doubt on that one. Okay, so Biden got sober the same month he married his current wife. He's remained sober ever since. Biden remained in California and spent much of 2019 painting and developing plans for his memoirs, which began working through the fall and into the winter. That's true. He's a painter. I definitely should buy myself a Hunter Biden. I definitely should buy myself a Hunter Biden. Could you guys contribute to my super chat fund? Could you guys donate to my PayPal? Could you guys donate to me so that I can please buy a Hunter Biden original and have it hanging in my apartment? I think it would look really good with my decor. During summer 2019, he was sued in 2 different domestic relation lawsuits, both seeking supportment of support obligations. I mean, I have been looking for a nomination to the federal bench, guys. I think Uncivil would make a good judge. Just saying. And for no particular reason and in no way related to that, I think also I'd like to have Hunter Biden's paintings on my wall. Please support me in my goals. Thank you. In or around November 2019, Biden engaged a California accountant to prepare his individual and corporate income tax returns for 2017 and 2018. The California accountant began gathering materials and started preparing Biden's 2017 and 2018 returns in early 2020. By that time, domestic relations lawsuits had progressed, and having failed to do so, Biden was under court order to pay tax returns or face potential sanctions, including imprisonment. On or about January 27th of 2020, Biden signed a representation letter for California accountants, averring that he was providing his accounts with truthful and accurate information and acknowledging his responsibility for accuracy of their returns. Over days that followed, Biden participated in a series of meetings with California accountants and identified business and personal expenses in connection with tax returns. During this process, Biden mischaracterized certain personal expenses as legitimate business expenses. No, you don't say. He mischaracterized personal expenses as legitimate business expenses? Okay. resulting in a reduction of his tax liability. At the same time, the California accounts are reporting Biden's income, which partially offset the reduction. On or about February 18th of 2020, Biden filed his individual and corporate income tax returns with the IRS for the tax returns 2017 and 2018. He's a little bit behind there. He's filing his 2017 and 2018 returns in 2020. He's a little bit behind. On his 2017 form, Biden reported $2.3 million in total income and self-assessed tax due of $700,000, of which $125,000 was timely paid, leaving a balance of $581,000. Dragon painting is right here. It's not on camera, but dragon painting is right over here on the wall. Don't diss dragon painting. It is right here on the wall. Dragon painting kicks ass. About a year and a half later, on or about October the 18th of 2021, a third party paid the Internal Revenue Service $955,000 to cover Biden's self-assessed individual tax liability with interest and penalties to cover the assessment. A third party, you say. A third party, you say. Paid Biden's taxes. How nice. If you would like to pay my taxes, please let me know. In addition, on or about February of 2020, Biden's California accounts discovered that Biden's 2016 form had not been filed. This return was originally prepared in 2017 and showed $15,000 in tax. Though it was delivered to Biden at Biden's office, the return was not filed with the IRS. After learning in 2020 that the form for 2016 remained unfiled, Biden filed a form. For tax year in 2016, Biden reported $1.5 million in total income and self-assessed tax due of $500,000, of which $447,000 was timely paid, leaving a balance of $45,000. Biden did not include a payment with its return. Hey, Jan, you want to see Ian? That's cool. On or about October the 18th, this liability plus accrued interest was also fully paid by a third party. For the 561 of you who are currently here, by the way, might I be so bold as to kindly ask you to make sure that you're subscribed? That's good because there's a decent possibility you've been unsubscribed. So, double check, hit the like button. And did you know for a mere 99 cents a month, you can become an uncivilian? It's true. By hitting that join button or hitting the link that the Streamlots bot tells you about, you can, for 99 cents a month, support this channel and help Uncivil in his goals and help up production quality and stuff. Thank you. Your support is appreciated. Let's see. Finally, after seeking an extension, Biden timely filed his return. In 2020, he did not, however, pay his estimated tax while filing an extension. For the tax year, he reported $1 million in total income and self-assessed tax of $197,000. This liability plus interest and penalties was also paid by the same third party. Wow. He's got some generous friends are there. All right. So the court picks up. All right. Thank you. Now, I did have a few questions. 5A says the amount of loss as to count 1 and 2, including the relevant conduct as defined in sentencing guidelines, is somewhere between 1.2 and 1.6. Is that the combined loss or the loss for each count? Combined loss, Your Honor. All right. In Exhibit 1, there are references to tax paid by a third party on Mr. Biden's behalf of $955 and $956, as well as $492 in 2016 and $197 for 2019. Just looking at those numbers add up to more than $1.9 million. Can you help me square that with the relevant conduct? Mr. Wise, so the amount that was paid by the third parties includes significant penalties and interest, which we've not included in the law stipulation that's in paragraph 5A. The paragraph in 5A is the taxes. And there's a dispute as to what the taxes were based on the business deductions and something the parties will address in their sentencing memorandum. But the number is a loss without incursion of penalties and interest. Is that standard? Yes, Your Honor. I'll take their word for it. Did you say something? I was going to say it's a relevant guideline, Your Honor, for failure to pay case. Thank you, Tina and the world, for becoming a member. Thank you for hitting that beautiful, beautiful join button. I was going to say it's a relevant guideline, Your Honor, for failure to pay case omits penalties and interest for calculation of tax table loss. There's a dispute about where in the range it goes, but under explanation, penalties and interest are not properly included in the guidelines. I Love Ad Blocks gives $20 to say, which Biden are you going to hang in your living room, Kurt? Well, for clarity, we're referring to paintings, and I don't know, whichever one will speak to me most. Whichever one will speak to me most. And I will talk with Hunter Biden, and we will figure out between us which painting is best painting for uncivil law. Because you got to find something that works for you, right? And we got to find something that works for the artist. So we'll make sure that there's synergy in our selection. Mr. Clark says, I was going to say it's a relevant guideline for failure to pay case omits penalties and interest from the calculation of loss. And there's a dispute about where in the range it goes, but in the explanation, penalties and interest are not properly included in this guideline. And for the tax evasion, would they be included? It's my understanding they would be, Your Honor, which, okay. Okay, paragraph 5B refers to the diversion agreement. That's the diversion agreement contemplated in the criminal action, the felony gun charge. Yes, Your Honor. All right, paragraph 12 refers to restitution and says the self-assessed tax due at the time of filing, associated interest in patents have been paid to the IRS by a third party on behalf of the defendant. What does self-assessed mean? It means the amount when the returns were prepared that the return prepared determined was owed based on the income that was reported and deductions and credit. I think, Your Honor, based on all this in the process, the numbers are based on payout numbers that were obtained from the IRS. Self-assessment is a process by which the returner files a written return, says this is how much I owe. There was a lot of process here between the IRS and these returns. At the end of the day, a payout number was obtained by the IRS and number was paid in the court. So that is what I'm trying to figure out. Is there someone still looking into that to see if the self-assessed number is accurate, or do you know that's zero? So the self-assessed number, again, is the amount on the return plus the interest and penalties that were derived through the payoff. After the statement of facts addressed, there's a dispute as to what the self-addressed number would be for 2018, and that will be addressed in the sentencing memorandum. To be clear, the dispute is we think it's lower. As statement of facts recites, there was actually an overstatement of the income that year. I mean, my understanding is all the monies that the IRS takes the position Mr. Biden owes as a result of every tax year being discussed has been paid based on their calculation, if I understand Your Honor's question. So they like a refund, which is pretty kind of funny. Biden's lawyer wants some money back. So our position, Your Honor, is that there are deductions that were taken that were improper, and that's so for why loss purposes, putting aside the payoff numbers, was our sentencing memorandum will address those. The IRS in arresting the payoff number didn't. Well, I'm just asking because you expected it to be zero. Why is it expected to be zero if you're telling me what the numbers might be wrong? Because that's the payoff amount that the IRS gave the defendant, which is sort of a process that produces that is separate from the criminal investigation and essentially divorced from it. That's why the agreement doesn't bind the IRS if they then make the decision essentially for additional restitution that could occur. Why are you expecting it to be zero? Because as the payoff number that was given, there's no at this moment restitution owed to the IRS. All right, so those are my initial questions. I may have some more as we go through this, but that's what I've had at the moment. Mr. Biden, does this written agreement as summarized by Mr. Wise accurately reflect the agreement you reached for the government? Yes, Your Honor. Have you felt threatened or forced to enter into the agreement? No, Your Honor. Has anyone made any promises that are not contained in the written agreement? Your Honor, with the exception of the diversion agreement, we're not making an exception. I want to know, has anyone made any promises that are not contained in the written memorandum of the plea agreement? Yes, there are promises from the government in the diversion agreement, Your Honor. Uh-oh. Uh-oh. Are there promises that are not in the agreement? Yes, Your Honor, in the diversion agreement. Uh-oh. And the court realizes that there might be a problem. And so are you relying on the promises made in the diversion agreement in connection with the plea? Yes, Your Honor. And if the diversion agreement were not valid or unenforceable for any reason, would you enter into the memorandum? No, Your Honor. Uh-oh. Uh-oh. All right, so we're going to discuss that agreement in a bit. For now, let me say, by the way, I didn't get a copy of paragraph 15 of the agreement, but both parties have provided me with a copy of the agreement prior to this hearing. So that's what I'm going to quote from at the moment. What is a diversion agreement? As the name sort of implies, the diversion agreement is a diversion between the government and a suspect to divert a case out of the criminal justice system towards some other venue. So it's sort of like it's a non-prosecution agreement. It's an agreement to forego going through the criminal justice process as certain conditions are met. So because the charges in some sense are never being brought in the first place, then they don't have to be approved by the court because they don't exist. So that's sort of what they are. Paragraph 15 of the diversion agreement states the United States agrees not to criminally prosecute Biden outside the terms of this agreement for any federal crimes encompassed by this attached statement of facts. Attachment A to the diversion agreement and the statement of facts attached is Exhibit 1 to the memorandum of plea agreement filed the same day. The agreement does not provide any protection against prosecution for any future conduct by Biden or any of his affiliated businesses. And just so we're clear, I think you already answered this, but you're relying on that promise in connection with your agreement to accept the memorandum of the plea. Yes. And if the provision were not valid, would you accept it? No. If you had no immunity from the government, perhaps even a different prosecutor and the government could bring a felony tax charge or drug charge against you, would you still enter the plea? No. All right, so I need some help here because you all told me this was a plea under Rule B and not A. But yet I have this provision that I would think is normally part of a plea agreement. So tell me, how do these agreements relate? Are they part of the package deal? So, Your Honor, the United States position is that the agreements stand alone by their own terms, and both agreements include in their last paragraph that says with this one caveat. That's a big caveat, though. If you're telling me that Rule B doesn't give me any authority to look into this, Rule A refers to, having an agreement not to prosecute. That's why I'm looking into this. I'm not saying you're wrong, but I need to understand it. Sure. So, Your Honor, again, our view is that the plea agreement stands alone. There is no charge bargaining in the plea agreement period. And that's what they agreed to, the diversion agreement. But he would not agree, just so I understand you, sir. You would not agree to the plea agreement if you didn't get some immunity from other charge. Speaking for my client, that's correct. I didn't mean that to be a rhetorical question. So you're telling me that that's separate, but I think, and I understand why I say no, that isn't separate to me. I need them both. That's the intention with the agreement he signed. So the intention of the agreement he signed was that it be completely separate, and the diversion agreement were not valid or enforceable. He'd be on the hook for other charges. He'd still be pleading guilty. That's right, because what the final paragraph of the plea agreement says he's agreeing to is the plea agreement stand on its own without any additional promises outside the four corners of the agreement. So there is a bit of dispute about what they're agreeing to, right? Because Biden says, okay, I'm, agreeing to this and I'm relying on this. And the government is saying, no, it's only the four quarters of the agreement. So there's a little bit of dispute here about what they're agreeing to, and you can't have that, right? You gotta see, because this is a contract. There's got to be a meeting of the minds. And if the contract says nothing outside this contract exists, then that's that. So what's the nature of the agreement? So the court says, do you need to talk about it for a few minutes? Yes. How about I give you guys an opportunity to make sure we're on the same page? Because part of my charge is to make sure the defendant knows what they're pleading to. We appreciate your honor. Then they take a recess. Then they say, Your Honor, I want to apologize for maybe my unartful phrasing for some of the issues that came up a minute ago. Perhaps I can clarify the defense position and clarify things. There are two agreements in this case. They're both very important to the defendant. One is a plea agreement the court has before it, and my client is ready to enter a plea to that plea agreement without contingency, without reservation, without connection. There's another agreement, which is a diversion agreement, Right. So let me just ask you, if the diversion agreement were not valid or were not enforceable for some reason, would he enter this plea? He's ready to live by the terms of that agreement. If the diversion agreement did not exist, would he be willing to live by the terms of the plea and plead guilty? I have concerns about that diversion agreement, so I'm asking you, if it were not valid, if it were unenforceable, would he plead to the memorandum of the plea? Based on our understanding of the diversion agreement, see, that's the wrong thing. Based on our understanding of the diversion agreement, which is a bilateral agreement between the defendant and the government, which the government has reaffirmed to me and will stand by, yeah, he would enter in the plea. The court says, so you're not answering my question. You're saying, well, we think it's valid and enforceable. I'm asking you, if it were not, go with me. If the agreement was not valid, if that agreement did not exist and he could not rely on it, would he enter the plea? You're asking for a hypothetical. Yes, I'm asking for that. Yes, my client would resolve this case on those terms in the hypothetical situation that exists without the diversion agreement. I want to be clear that's the party's position, that there's a diversion agreement between the parties, which is binding. But take that out of today's proceedings, and my client is ready to enter a plea under that plea agreement. Okay. So he's ready to plead on this without the diversion agreement? All right. All right, let me ask you the questions again, Mr. Biden. If the diversion agreement were not valid and enforceable for any reason, would you enter the memorandum of plea agreement? Yes, Your Honor. And are you relying on the promise in the diversion agreement not to prosecute you in connection with your plea? No. Okay. And so if you had no immunity to the government through the diversion agreement, and the government could bring felony tax charges or drug charges against you, would you still enter the plea and plead guilty? Yes. All right, now I want to talk a little bit about this agreement not to prosecute. So that's fun. All right. The agreement not to prosecute includes, is this the gun case, but also includes crimes related to the tax case. So we've looked through a bunch of diversion agreements that we have access to. We couldn't find anything similar to that. So let me first ask you, do any precedent for agreeing not to prosecute crimes that had nothing to do with the cases or charges being diverted? So what they're talking about is in a diversion agreement only relates to the case at hand. It doesn't relate to any other things. So diversion agreements, to the extent they exist, and we'll talk about like criminal justice in general to move it out of the federal system a little bit. But diversion agreements, to the extent they exist, are for a specific issue and not with respect to any other issues. So, for example, not uncommon would be like a first-time drug offense, right? Would be an example where this might be true. Like a first-time drug offense would be common, right? So it's your first-time drug offense, and you reach an agreement with the prosecutor. It's like, okay, we're not going to prosecute you if you do X, Y, Z, or if you go through this other program, or if you go to this special drug court, or if you do whatever, right? So it's a show of mercy, right? It's a show of mercy. You get one for free. It's not a guarantee. It's not a guarantee, right? But it's something they can do. It's like, all right, this is your first time. We don't want to screw up your record. We'll give you one for free, or almost free. because usually you have to do something. But that's the thing, right? It's only for the one thing. It doesn't contemplate any charges outside of it. So what they're saying here is this would be a little bit like, you're charged with a drug violation, and also we'll agree to give you a buy on the drug violation, and also we're going to put aside this, I don't know, theft charge. I don't, we'll put aside this theft charge. That's not really how that typically works as a part of a diversion. So this court's like, there's more than one thing here. That's not usually how we do this. So, yeah. Everyone in chat having a good time? Everyone learning some things? Everyone having fun? Making sure that we see if there's any questions floating around in chat. I try to look over from time to time to make sure that we're following along. Is agreement not to prosecute the same as the diversion agreement? Well, broadly speaking, yes, but different jurisdictions use the term differently. So it depends. It's not necessarily a thing of universal nomenclature. So the specific language might change. So broadly speaking, sure. I think saying that a diversion agreement and a agreement not to prosecute can be thought of as the same. I suppose a diversion agreement is slightly more formal because it typically implies a formal thing, like we're going to formally require you to go to like this particular drug rehab. So maybe it's slightly more formal, but if you think of them in the same category, I think you're fine. Okay. And different jurisdictions use the terms differently. And also different jurisdictions have different kinds of diversion programs and different kinds of courts. So some places have like a special veterans court. Some places have a special domestic violence court. So it just depends on the details of how the state operates things. Okay. So they say, so let me ask you, do you have any precedent for agreeing not to prosecute crimes that have nothing to do with the case? I'm not aware of any. Do you have any authority that says it should be appropriate, that's appropriate, and that the probation officer should agree to the terms, or chief of probation should agree to the terms of diversion? Your Honor, I believe that this is a bilateral agreement between the parties that the parties view in their best interest. I don't believe the role of probation would include weighting the benefit of the bargain is valid or not from the perspective of the United States. Yeah, that sounds right. Why would we ask them whether or not they agree? They're not part of this equation. So have you ever seen, I think you just asked you this, but have you ever seen a diversion agreement where the agreement not to prosecute is so broad that it encompasses crimes in a different case? No, and I would say, Your Honor, that I don't think it is broad in that sense. We're going to talk about it. You can sit down. Oof. Yeah. So the court's like, okay, you answered my question that it's inappropriate. Now let's discuss that why you're doing that here. All right, now is this an agreement not to bring charges or agreement to drop charges typically something that's included in memorandum of plea agreement? Yeah, that would be pretty typical. Yeah, that would be very typical. Especially like that'd be incredibly common. To not bring any charges relating to the same transaction would be very typical, or to drop issues. So to talk about a situation where an agreement not to bring charges or an agreement to drop charges that's included in a memorandum of plea, yeah, that would be very typical. So the way that this would most often pop up, but not necessarily the only way, would be what we consider to be the criminal transaction, which is a somewhat loose concept that defines all the crimes that are related to a particular contemporaneous or relative contemporaneous set of actions, closely related in time and space, closely related in purpose. It's a little bit fuzzy. The example I always use to illustrate the point is like a bank robbery. I'm not sure, but that's what I go to, right? A bank robbery. All right. So let's suppose that you stole a car for the purpose of using it as a getaway car for the bank robbery. Okay. So it's probably true that the car theft is part of the same transaction as the bank robbery because they're closely related in time and space, closely related in purpose. The purpose for stealing the car was to facilitate the bank robbery. So they are separate crimes. They're legally distinct. The one does not imply the other. There's nothing about a bank robbery that implies a theft of a car, and vice versa. They are completely distinct crimes. Nevertheless, because they're closely related in time and space, because they're closely related in purpose, they would often be thought of as part of the same criminal transaction. You know, if you went into the robbery and you told everyone to get on the floor, for example, that might be kidnapping. Or you told them to move into a back room, that might be kidnapping. If you slapped one of them around or something, battery, right? And so forth and so on, right? These are all part of a contemporaneous, holistic thing. All right. So let's say the government is prosecuting you for this bank robbery and its many associated offenses, right? Charges 1 through 10. Okay. For all their various combinations. All right. So the government might agree to drop some of those charges, right? There's 10 charges pending. You plead to some of them, we drop other ones. Typically, you're going to plead to the top counts, and then they'll drop some of the more minor stuff. Right? So the government agrees to dismiss counts 5 through 10 in exchange for a plea of counts 1 through 5. Right? So we agree to dismiss charges. Okay. We can also agree not to add charges because although we have charged you at this point, and at this point, of course, could depend where we are in the criminal process. How early or late are we in the investigation? Because maybe there's still other things we haven't discovered. Maybe the government hasn't figured out yet that you stole a car. Maybe they didn't figure that out yet. Because you stole the car for the getaway, you did the getaway, you abandoned the car once you were done with it, and by the time the government caught up with you, you were not in the possession of the car yet. So the government has not yet figured out that you stole the car for the purpose of being part of the robbery. So they haven't charged you with it yet because they haven't figured it out. But maybe they will. Maybe they'll figure it out as they're continuing their investigation, right? So one of the things you'll say is, okay, I don't want you to add any new charges. I don't want you to charge me with other things relating to this that you haven't figured out yet, right? Again, it all goes to knowing, intelligent waiver. So the government is giving up, these other crimes that they haven't discovered yet, potentially, in exchange for your plea. So magical charges 11 through 15 will never come into existence because you agreed to get rid of them as part of the same transaction. So that is the most common way it would pop up. Of course, it doesn't necessarily have to be the same transaction. It could be completely unrelated crimes, although that would be a little bit more atypical, but sure, right? So it could be, I don't know, what would be an example? It could be, well, I suppose you stole a car for some other purpose other than the bank robbery in a place that's not, in a situation that's not relatively contemporaneous with a bank robbery. So you are just a thief, and as two completely independent transactions that have nothing to do with each other. You've stolen a car and robbed a bank. They have nothing to do with each other. To make it a little bit clearer, you didn't even use the car during the robbery. You used a bus instead. Yeah. That you got on the city bus and you paid your fare and everything with the money you stole from the bank, and you got away on that pesky city bus. Police aren't very good at their job here. Okay. So because these are completely unrelated things, but you can be like, well, will you dismiss this case if I plead to this case? So that can happen too. So that's kind of what they're talking about. All right. Just to give you some legal education there. All right. So Would you see an agreement to drop charges or not pursue other cases as part of a plea? That would be common. Ever included in the agreement, would they make the plea agreement one pursuant to A? Yeah, it would. So if we did that, it would make it under this rule, not this rule. So they say yes, that would be true. It would be under Rule A. In your view, that would change the analysis of what I need to do in evaluating whether to accept the plea or not, right? It would. And so let's just understand this. If that were, my role would be to accept or reject the plea. It would. What happens if I accept the plea? We go forward to sentencing, yes. And what happens if I reject the plea? Then this is one of the issues with charge bargaining because of the waiver of venue. Well, there's a waiver of venue, but also, and this has been addressed by some courts outside the circuit, because of separation of powers, if the court were to reject C1A on the view that the charges should be different, well, what if I were to reject the C1A plea on the grounds that includes an agreement not to prosecute, that, as we talked about in a few minutes, I don't really understand the scope of? I mean, forget all the investigation. What charges were brought? I think the parties have made clear that we live in a system of separation of powers, that these are powers given to the executive branch, right? Right. So I don't mean to violate the separation of powers or do anything unconstitutional. I'm trying to figure out what my role is and what the appropriate rule is. Okay. And so I'm trying to understand that if I were to reject the plea, I'm not saying I'm going to, I have not, for anyone in the back, I've not made that determination. But if I were to reject the plea, just tell me what happens. So we have two charges against the defendant and they're misdemeanors. So he doesn't need to be indicted, which is true. You don't need to indict for a misdemeanor in the federal system. So we go forward, and if there's a trial on those charges, there's a possibility there's additional charges that could be brought. Related to tax issues, yes. Do you agree with that, Mr. Clark? What would happen? Again, I want to make sure I'm not saying that is my decision. I understand, Your Honor. I don't necessarily disagree. I'm not aware of any additional charges that could validly be brought with regards to the tax charges, which is probably true. Again, without getting into the whole investigation, but I do think there's some context that's important here. United States Attorney and me spent 5 years in meeting after meeting, hours, 10-hour-long meetings, going through my client's taxes on a line-by-line basis. And this disposition the parties came to after a 5-year investigation that we pursued with unbelievable diligence and doggedness. And so, first of all, I don't think there are any other charges that could be brought, which, fair enough. They've exhausted this. There's nothing left to do. I think, though, that we, just like any other compromise situation, we have vowed agreements with regard to these charges, but my client undertook to plead them guilty because it was the right disposition for all the parties after extensive negotiation. And so, yeah, I think we'd have two informations for the court, and the parties would figure out how to proceed on those informations, and that would be the rest of the process. That sounds about right. Kristen says, you're the only one to explain this to we common folk. Thank you. I've been listening to an hour and we'll watch again. Well, thank you. I try to explain this. I try to make it as easy as I can to understand and I really try to work my craft. I try to be a very good teacher. I want you to understand this. And so I appreciate the compliment. It's very thoughtful. Thank you. All right. So you say there might be additional charges. Are you at liberty to tell us what you're thinking? Those might be, or is it just hypothetical? It was hypothetical in response to your question. Is there an ongoing investigation? There is. May I ask then why, if there is, we're doing this piecemeal? Your Honor, I may not ask, but we're in a position where we could say. Well, that in of itself isn't necessarily problematic because, especially if you're dealing with, and there could be a lot of reasons for this, right? Different statutes of limitations, although that's less a problem in the federal system. Or different things are ready at different times. So if you're investigating someone who has done many criminal misdeeds and are just getting caught up to them now, which incidentally you'd see more in a white crime situation, but I suppose could happen in blue collar crime as well. But it would be more common in a white collar crime situation. White collar crime, it tends not to be the first one that gets you. Most white collar crimes tend to start out pretty small. Of course, that's not always true. See St. Bankman-Fried. But most white collar crimes tend to start out pretty small. And people just get bolder and bolder and bolder and take more risk and more risk and more risk. And they take more chances and more chances and more chances until eventually one day they push it too far. And then someone notices and they start doing an investigation and they uncover the entire sequence backwards, right? Once they have a reason to look, they uncover the entire trail, right? So that's sort of common. So if you had that situation, it might be the case that pieces of that would mature in terms of being ready to go to trial versus other pieces. Because, if you had a person, especially if the person were not doing like the same white collar crime, but were doing lots of different crimes that were independent of each other. So, if what they were doing is banking fraud and just doing different versions of banking fraud, that would be easier to figure out than, say, for example, someone who did a banking fraud and did a theft of a car and did this and did this and did this and did this, right? That are disconnected from each other and not related in sort of their mode of operation, which is atypical because most criminals tend to have an MO. So it's more common to have the guy who, wants a bank fraud, always a bank fraud. I'm good at the bank fraud, so all I do is bank frauds. I'm a specialist in the bank frauds. So that's much more common. But, occasionally you'll have someone who is a jack of all trades kind of criminal and dabbles in a whole bunch of unrelated stuff. Either way, it is possible that different elements of that will mature at different times. And you'll be ready to go at different times. So it is possible in that situation that you might want to wait until it's all ready to go. But due to statute of limitations problems or other problems, that may not be possible. So you might very well have some cases that are ready to go to trial while you're still having an investigation underway. And so again, the question would be, what is the nature of the agreement between the parties? And what do you know? And what do you know that you don't know? So what do you know that you don't know? And you take the risk that, behind that door is that super secret evidence. But, so that's what they're talking about. So they're asking why they're doing a piecemeal. And he says, I can't say. Which, fair enough. I think what I'm concerned about here is that you seem to be asking for inclusion of the court in this agreement. Yet you're telling me I don't have a role in it, and you're leaving provisions of the plea agreement out and putting them into an agreement that you're not asking me to sign off. So I need you to help me understand why this isn't in the written plea agreement. A good question. If I may, Your Honor, I mean the original conception here was something like a deferred prosecution, non-prosecution agreement, which the court doesn't weigh in on. That's true. I don't think it was. We're not asking the court to rule in any way on the diversion agreement. Diversion, as far as I understand, has been approved by probation. There is arraigned the defendant on the instrument, and I believe the process will go forward. We have to talk about the diversion agreement because you've included me in the diversion agreement. So we're going to talk about it. But as I'm still, normally, so we have two agreements. We have a plea agreement where you're saying, Judge, we're all here in front of you, ready for him to plead. You're saying I don't even get to accept it. I'm just supposed to rubber stamp it under Rule C1B. But then it would be a plea under Rule A if the provisions that you'd put in the diversion agreement, which you don't have any place for me to sign, it's not my purview under the statute to sign, so you put it in the provision under there. So I'm concerned that you're taking provisions out of the agreement, out of the plea agreement that would normally be in there. So it's basically like you're playing games, right? This agreement with this whole Hamilton asks, this is a question why they didn't bifurcate. Well, they did initially, and then they brought them both together because, I don't know, convenience. So they were bifurcated, and the judge is like, well, I'm going to arraign them on both. And then the judge is like, I'm going to go talk about them in the same breath for convenience. So I suppose in some sense they are strictly bifurcated even as we speak. We're just talking about them both at the same time. Because the court thought it would be better in the interest of efficiency, which makes sense. So what the court now was saying is look, there's a rule for different kinds of plea agreements. If this was a B-type plea agreement, then there's nothing for me to do. Just agree to it and move on, right? But if this is an A agreement, then I can at least theoretically reject it in the interest of justice. So a B agreement is we're pleading guilty to all the charges, but with a sentencing recommendation. So in that situation, the court agrees to it, but there's nothing for the court to disagree with. There's nothing for the court to disagree with, fundamentally. Like, there's nothing for the court to disagree with, because all the parties have agreed to is a recommendation, which the court can agree to or not. So the resolution under B doesn't really give any role for the court, because they're like, well, this is the charge we're bringing. You agree to plead guilty. Here's the maximum penalty. We've agreed to this recommendation. So there's kind of nothing for the court to do except to impose sentence, which is completely independent of the plea. In the A agreement, it also includes other crimes that are not being charged, other crimes that are being dropped, other things that are being done, downward departures of crimes. So in that situation, there is something for the court to do, because the deal might be against the interests of justice. Because if we go to our bank robbing case with the 10 charges that, brought, right? What you would expect in the situation where the prosecution is going to drop some of the charges, they're going to drop some of the more minor stuff. All right, so you plead guilty to the bank robbery. We drop the theft of the car. We drop some of the other stuff. You plead guilty to the robbery. Top count. And of course, fine. But let's imagine a prosecutor goes the other way. And we're gonna drop the bank robbery. We're gonna drop the theft. We're gonna drop the kidnapping. But we are gonna get you for speeding. Because as you were going away from the bank, you went 70 miles an hour in a 65. So you agreed to plead. You agree to all the facts. And the only charge you plead to is the traffic infraction. Well, a court might have a problem with this. A court might say, that's not in the interest of justice. The parties agree. They both agree. The defendant agrees. They did the bank robbery, and they did the car theft, and they did the kidnapping, and they did the terrorism with the explosives and everything. So they agree to all the facts. And what you want to get them on is the speeding. And the court can be like, well, that doesn't make a lot of sense. That's not in the interest of justice. Go away. I'm not agreeing to this bullshit. So what the court is noting here is that you have attempted, well, I don't know if you attempted, but you have in fact taken this A agreement and rewritten it in a way to make it a B agreement by going through this diversion process. So you've tried to be very clever as lawyers, which, fair enough, but you have also enlisted my role as a court, which speaks to me and my value. So, you as attorneys with your creative machinations are super wonderful and encouraging in everyone. But, when you enlist me, I'm going to make sure that, this isn't some bullshit. So that's what they're talking about. So the bargain that was reached by the parties was the plea agreement that was in front of your honor, which is a B agreement, as I mentioned, where there's only a recommendation sentence. So this isn't an A agreement because it doesn't contain A features. And then the court says, well, it's not, because you reference the diversion agreement. Not in the plea agreement, they say. They says you do. I ask you if paragraph 5B refers to the division agreement, and you said yes. Only insofar as it's not relevant conduct. You reference it in the plea agreement, right? But it doesn't incorporate it. And the diversion agreement, you reference the memorandum of the plea agreement, only part of it. And you say in the diversion agreement where you say there's not going to be any prosecution, you say it's not just prosecution on the gun charge, which is the subject of the diversion. You also say no prosecution with respect to anything in the statement of facts attached to the memorandum of the plea. Yes. All right, so I don't really understand why that's not in the plea. Because by terms of the plea agreement, the only function, the diversion agreement, well, it has no function, but the parties negotiated that their view, and it is their view. Probation can take a different view, Your Honor. Can take a different view. Their view is the firearms offense should not be considered relevant conduct for calculating the guidelines relevant to the tax offense. That's all that 5B says, which, okay, fair enough, right? So the fact that you've engaged in other criminal behavior could be used as a factor in sentencing. Because when you talk about sentencing, there are two major categories when it comes to sentencing somebody. How bad is this thing? And how bad have you been in general? Your history of offense. So how bad is this crime? How bad are other crimes? Well, when you have two crimes at the same time, they both could inform the other potentially as prior acts, or at least acts that aggravate them. So not only are they bad in their own right, but the fact that they're now prior history with respect to each other, or they could be, right? So they could be viewed as prior history with respect to each other, because now you've done multiple bad things, and they're going to start to stack. So what they're saying is, we don't think they should stack. So for the purposes of it, we're going to treat them both like there's no criminal history, which, fair enough. Fair enough. I have no particular problem with that, right? They're being charged contemporaneously. So we'll apply the history that applied before this all started, and you had no history, so that's fine. That's fine. It does not incorporate paragraph 15 or any part of the diversion agreement. It simply says our view is the diversion agreement, the firearms offense should not be relevant in calculating the guidelines. I think practically how this works, Your Honor, is if Your Honor takes the plea and signs the diversion agreement, which is what puts it in force as of today, and at some point in the future we were to bring charges the defendant thought were encompassed by the factual statement in the diversion agreement or the factual statement in the plea, they could move to dismiss those charges on the grounds we had contractually agreed not to bring the charges encompassed within the factual statement. And then Clark says, that's my understanding of, or Your Honor, we'd be enforcing a contract with the Department of Justice. Which, fair enough, that's what it is. But of course, while this is viewed very similar to a contract, and if you understand contract law, you understand a lot of plea agreement. It is a special kind of contract, a plea agreement. So this does have some different features from your ordinary contract, right? So they say this is just a contract between the parties. And the court's over here like saying, well, I don't understand how you can have an agreement not to pursue, but it's not part of the plea agreement. It's like, how can you have an understanding that's not part of the contract, particularly one where you want to get me involved? And they say, because the plea agreement does not include that. All right, so let's talk a little bit more about that. To the extent the agreement, you can sit down. To the extent the agreement not to prosecute is promised, do the parties have some understanding what the scope is? Yes, Your Honor. No, tell me, like specifically, what does it include? You say there's an investigation. I don't know what that is, but you must know if there are particular charges that could be brought based on the facts that are there. So I can tell you what we think we can't charge. I can't tell you what the ongoing investigation is, which, fair enough. They don't reveal ongoing investigations while they're investigating. So, fair enough. So for instance, I think based on the terms of the agreement, we cannot bring a tax evasion charge for the years described in the statement. And I think we can't bring a firearms charge based on the firearms identified in the factual statement, which would make sense. That would make sense, right? We can't bring another firearms charge with respect to that particular firearm. We can't bring any more tax charges with respect to those particular tax years because we are dealing with this and this is the end. So that makes sense. All right, so there are references to foreign companies, for example, in the fact section. Could the government bring charges under the Foreign Agent Registration Act? To which they say yes. To which I would note that Hunter Biden is totally guilty of violating the Foreign Agents Registration Act. There's just no way. He is so guilty of violating the Foreign Agents Registration Act. Other people have been prosecuted for being associated with the exact same energy company that Hunter Biden was. And Hunter Biden was doing more with respect to them than other people were. So Hunter Biden is totally in violation of the Foreign Agents Registration Act, it seems to me. I'm trying to figure out there's a meeting of minds here. I'm not sure this provision isn't part of a plea agreement, so that's why I'm asking. Your Honor, the plea agreement. I need you to answer my question if you can. Is there a meeting of the minds on that one? As stated by the government just now, no, I don't agree with what the government said. Uh-oh. So the government says, yes, we could bring a FAR prosecution. The defense says, no, you can't. Uh-oh. So we have a problem on the meeting of the minds. So, I mean, these are contracts. To be enforceable, there's a meeting of the minds. So what do we do now? Then there's no deal. Right. Correct. You have reached the correct legal conclusion. Congratulations. A contract is about meeting the minds. There is no meeting of the minds. What does that mean? There is no deal. Correct. You have reached the correct conclusion. All right. So I guess the question is, what does that leave us? So what do we need to do? You guys need some time to talk. Do you need me to set a date? Do we not need to talk about preliminary hearings since we really don't have one with agreement? We'll waive the preliminary hearing, which, is not atypical, particularly in this case, right? Because this isn't a case like, I don't really do criminal law. I've never really done criminal law, but I wouldn't think this is a case where you need to do a preliminary hearing because you kind of know what the evidence is and you kind of know what they're going to look for. So there's no particular need for it. So that's fine. As far as I'm concerned, the plea agreement is null and void. We're going to have to discuss things with the government. All right. So I think we're on the clock now because this is, after all, an initial appearance. This is an initial appearance. So the court says, okay, well, that means we're on the clock because this case now is underway. So we got to start rolling, So what should we do? Do you want me to set a date for pretrial motions? Do you want to exclude a little bit of time so you have some time to talk? What do you want to do? I think we need 30 days after the trial clock to figure out what's going on. All right, I agree. I know this has come as a little bit of a curveball, but I think having you guys talk makes some sense. And we'll exclude the time up, so 30 days takes us to Friday before Labor Day. Do you want that or the following week? I think that'll be fine. So the court will give them a little additional time because, we're on the clock, so let's get started. So we'll exclude up to September 1st then. You guys get me a status report. I think it makes sense in the interest of justice to do that. We'll get a status report and figure out where we are. Your Honor, can we ask that you take 10 minutes and see whether we can make some headway? Okay, thank you. All right, can we have a quick 10-minute powwow to see if we can somehow bring this all back together? All right, be seated. Where are we? Your Honor, we've had discussions between the parties to try and clarify the understanding. I just want to kind of summarize where we are. If government counsel wants to correct me, the parties have taken the position that the diversion agreement is a separate agreement from the plea agreement. The diversion agreement is a bilateral contract between the parties. Your Honor's asked the parties what their understanding of paragraph 15 of the diversion agreement is. I think there was some space between us. At this point, we're prepared to agree with the government that the scope of paragraph 15 relates to specific areas of federal crimes that are discussed in the statement of facts, which in general and broadly relate to gun possession, tax issues, and drug use. So you're going to rewrite that? The government says that what it means in the court, and Your Honor asks for the parties to agree. I'm just looking at the language of that. So if you're comfortable, that's what it means, even though the language seems substantially broader. Your Honor, I've just put it on the record what we have. You didn't just answer yes. So that also, are you comfortable with that provision? It means only what it relates to and for what period of time. It would be the period of time in the statement of facts, both statements of facts. Help me out with that. 14 to 19 for the tax offense and the drug, and the omission of the drug use in that period. And the firearms is obviously specifically identifying the time period in which it is possessed. All right. So defense agrees that the agreement not to prosecute only includes the time period from 2014 to 2019. It only includes tax charges in that time period, drug charges in that time period, and in particular, the firearm charge that relates to this particular firearm. Yes, Your Honor. All right, so you can be seated. So the court has now clarified the contract, right? Only these things, just these things, and nothing more. So good on the court for clarifying all this. Joy's Chick, thank you for tipping $10. I appreciate you for tipping $10. Everyone who helps to support the channel is appreciated and loved. All right, so you can be seated. Let me just take a look here. I mean, part of the issue is I'm having understanding, regardless of whether this is a plea under subsection B or subsection A, It has to be a knowing plea. I'm already faced with the defendant under oath saying he would not enter the memorandum of plea if the diversion agreement were not valid, and that he would. So he said both things. And so I'm a bit confused there. So I think we can work through that, but let's take another look at the rest of this. All right, sir, other than what's just been discussed, are there any other promises that have been made to entice you to enter the plea? No, Your Honor. Do you understand that this is the time to tell me of any promises not on the record or of any threats that have been made to you? Because after today, you won't be able to withdraw your plea based on the information you could have shared with me. Yes, Your Honor. Do you understand the plea? The terms of the plea agreement are mere recommendations to me. That I can reject those recommendations without permitting you to withdraw your plea and impose a sentence that's harsher or longer or more severe than the one you anticipate. Yes, Your Honor. So I can sentence you to anything. Anything. And if I do, you can't withdraw your plea. Are you pleading because you are in fact guilty? Yes, Your Honor. All right, now I want to walk through specific provisions of the agreement. First, venue. Do you have the agreement in front of you? Yes. All right, so paragraph 1 states that you waive any challenge to the information based on venue. Do you understand that absent waiver, you could challenge this court as being the appropriate court to hear these charges? So not the District of Delaware, but the District of, I don't know, Rhode Island. District of Delaware is almost certainly the correct court. It's kind of a formality, but still. Yes, Your Honor. By entering this plea, you're giving up that challenge? Yes, Your Honor. Did you discuss that provision with your counsel? Yes. Are you satisfied? Yes. Now, in the next paragraph, paragraph 2, Mr. Wise went over maximum penalties for count 1 and 2, where he summarized the essential terms. And I mentioned those to you earlier when doing the initial plea. Do you understand what the maximum penalties are for each of the counts that are pending? Yes, Your Honor. Do you need me to go through them one more time, or are you okay? No, Your Honor. Thank you. Paragraph 3. Paragraph 3 lists the essential elements of count 1 and 2 that the government would have to prove. Specifically, for each count, the government would have to prove, beyond a reasonable doubt, the defendant, you, had a duty to pay tax. 2, the tax was not paid. 3, that the failure to pay was willful. Do you understand if I accept your guilty plea, the government will not have to prove anything? Yes, Your Honor. Paragraph 3 also references the statement of facts attached to the plea exhibit. Mr. Wise read those into the record, and was something not common in my experience. I just want to ask you about some of those. I'm not going to go through all the facts, but I want to ask them because it's part of the plea agreement that's being presented to me, and particularly our discussion about the fact those facts are incorporated into the agreement not to prosecute. So this is not atypical to do it separately or together, either way, but you'll have a statement of facts, right? You'll have a statement of facts, either part of the plea agreement or separate to them, that lays out the essential facts as understood by the government and the other parties, right? So we'll lay out the critical details. And it's basically everything that they think that would be proved at trial, right? So here are all the facts, here are all the dates, here are all the things, here's what you did, right? And that you are admitting to all these facts. So it's acknowledging the legal and factual basis for the charges. Thank you, Jennifer, for the 5 gift memberships. It is extensively appreciated. We appreciate everyone who helps the channel by hitting that join button or by hitting the super chat button and donating some gift memberships. Everyone who's a member kicks ass. Non-members are jelly, as they should be, but they don't have to be, because all they have to do is hit the join button. All right, I'm not going to ask about all those facts. I want to ask him because it's part of the plea agreement that's being presented to me, and particularly our early discussion about the fact those facts are incorporated not to prosecute. Do you have those in front of you? Yes. All right, so in the very first paragraph of Exhibit 1, it says towards the end, it says through at least early 2017. I think before that, in the first paragraph. In the second sentence, it says from 2017 to 2019, you served on the board of a Ukrainian energy company and a Chinese private equity fund. Can you tell me what those companies were? The Ukrainian energy company was Burisma, and the Chinese private equity fund was Bohai, Harvest, and Rosemont. And some of this I'm asking just so I understand, because with other references to Ukraine companies and Chinese companies, I can't tell if they're the same company or not, so that's part of what I'm asking. Later in the paragraph, it says, through at least 2017, you were employed by a prestigious multinational law firm in an of-counsel position. It says through at least 2017. What were those years? Do you remember how long you worked there? Your Honor, I think I was at Boyes Schuyler in 2010. Maybe that's why I'm started, but I'm not positive that. That's why I believe. Okay. And you were in counsel position the whole time? Yes, Your Honor. And now it says for you, the work you did, you earned $2.3 million in 2017 and 2.1 million in 2018. That's a lot. That's a lot. That's a very healthy lawyer salary, especially for the of counsel role, which, as I mentioned, is a little bit more ad hoc and a little bit more specialized and typically a little bit more detached than a normal associate role. So Hunter Biden over here gets $2.3 million as an attorney in 2017 in an of counsel role. He must be really good. He must be a targeted specialist. He must be a target specialist that is outside the normal practice of the law firm. So maybe he's like an IP lawyer specialist, right? Maybe he's like a patent lawyer like me, right? And this firm doesn't do any patent law. Okay? Their firm doesn't do any patent law, but he's a patent lawyer. But he's a really, really good patent lawyer. So even though it's outside the firm's normal experience and not anything they normally do, but he's just a really, really good patent lawyer. So they bring him in this of counsel role because it's a little different than what they normally do. So we're not going to make him a normal associate because he's kind of a mercenary, kind of, and we're bringing him in, and he just drums up, and he earns 2.3 million. He doesn't even bill 2.3 million. He earns 2.3 million, which means he probably bills 3 million, 4 million, 5 million, 6 million. I mean, this guy is just really good. Wow. He's the best. And then he left the firm. I guess because his talents were needed elsewhere. He's taking his talents to Miami. Yes, Your Honor. So can you tell me? I'm trying to understand 2018 2.1 million. My understanding, Your Honor, is the sentence picks up the work described in the last couple of sentences. Now it's just the work for Boyce Scholler. Oh, okay. So this wasn't just the work he was doing for that firm. That was all the money he was doing. So he was doing other work outside the firm, which makes sense for the of counsel role. So that wasn't all work he was doing for the firm. He's just kind of there sort of as he's there as a mission specialist. Come in, get out. Yes, Your Honor. I believe what the government intended was a total income, not just it relates to capacity for Boyce Schiller. So for all your work, that's for all things you did there. What did you do? How in God's name did you earn that money? What exactly were you doing? How good a lawyer are you? All right, thank you. It says in the next paragraph, you have a well-documented, long-standing struggle with abuse. And you did tell me that already. I'm not going to ask about your efforts to treat that. But we're talking about well-documented. Is there a particular thing you're looking at for it's documented or just based on the discussions? Well, I believe the government is referring to a book I wrote about my struggles with addiction in that period of my time of life, and quite possibly other news outlets and interviews and things I've been done. Okay, in the next paragraph, it refers towards the middle. It refers to your struggle with addiction that led to the collapse of your most significant professional relationship. Is that referring to the law firm or something else? My business relationship, my business relationships, all my business relationships, ultimately including the law firm. I had a business that was Rosemont Senia Advisors and a long-standing business partner from the inception of that company that started, and others that collapsed during that period of time. So one of the businesses was Rosemont Seneca. Were the others that collapsed? The one reference here was Owasco. Virtually everything collapsed. Owasco is a holding company for all the other companies below. And okay, who was your business partner? A gentleman named Eric Schwinn. All right. The fourth paragraph says, during calendar 2017, you earned a substantial income, including just under $1 million from a company you formed with the CEO of a Chinese business conglomerate. Is it the same or different Chinese company from one you referenced earlier? I started a company called Hudson West, Your Honor, and my partner was associated with a Chinese energy company called CEFC. That would be the Chinese government, by the way, as previously determined by the US government. That would be the FARA violation. CEFC is the Chinese government. And who is your partner? I don't know how to spell his name. Yi Yingming is the chairman of the company. You don't know how to spell your partner's name? That's encouraging. Is the company still in existence? No. Okay, then it says you made $666,666 from your domestic business interests. Is that the Rosemont Seneca once? Yes, Your Honor. I believe that's what it refers to. $664,000 from a Chinese infrastructure investment company. Is that one of the companies we've already talked about? I believe so, yes, Your Honor. Which one is that? I believe CEFC. Well, that must be nice. That must be nice. He got $664,000 from a Chinese infrastructure company, but he's not exactly sure which one. I mean, Your Honor, I get so many checks of such big dollar amounts. I mean, I can't expect to be remembering all this. I mean, that's ridiculous. Was the $664,000 from the CEFC, or was it from this company or that company or this company? I mean, I just can't keep all that straight in my mind, Your Honor. It's just $664,000 might sound like a lot of money to you, but to me, it's a day that ends in Y. Okay. All right, and $500,000 in director's fees from Ukrainian energy company. Is that the one you told me about? Burisma. $48,000 from the law firm? Yes. That's Boris Schiller? Yes. Is $48,000 all he got from the law firm? If so, then he's being paid much more appropriately. All right, the bottom of the first page, the final paragraph says the accountant sent copies of tax documents. Copies of the tax documents to your former business partner. Is that Mr. Sherwin? I believe that's who it's referring to, Your Honor. All right, the next page, at the end of the second paragraph, starting 4 lines from the bottom in the middle of the line, the paragraph talks about tax liability. And since the end of your liability should not have come as a surprise. Do you see that? I'm sorry, I'm just trying. It's okay, take your time. Yes, I see it here. It says it should not come as a surprise. It wasn't a surprise. Is that right? Yes, Your Honor. And you knew? Well, I didn't write this on, Your Honor. So the characterization. Yeah, but you signed it saying that you agreed to it. So if you didn't agree with it or you had problems with the language, why didn't you change it? Is it possible? Now, I know this is just a ridiculous question. And I'm so sorry for asking it, because clearly it's not true. And I'm so sorry. But he says he doesn't agree with the characterization. Now, Hunter Biden, who is truly the best lawyer of any lawyer I've ever heard of, knows how to write a contract. Is it possible, and again, forgive me, but is it possible on this one fleeting occasion, he may not have deployed the full weight of his intense legal skills and might have signed a contract without fully reading or understanding it? I know that's just a scandalous, even slanderous thought to speak out loud. Because I mean, clearly he is a man who understands contracts, and he wouldn't sign off on a contract without reading and understanding every word of it and quibbling over the freaking placement of the commas like, the most basic of basic attorneys would do. The most basic of basic attorneys are going to go quibble over the comma placement. And he, being, best attorney ever, surely would not sign over a contract without understanding every word, every context, and if he had a problem with any of it, negotiating other language. Is it possible that maybe this one time he might not have fully read it or understood it? What a departure. What a departure from the legal acumen that is Hunter Biden. Clearly an aberration in an otherwise illustrious legal career. Can we elaborate the time there, Your Honor? Yes. So essentially, there was a tax treatment that was taken that year and changed the tax treatment at the very end of the year for a particular asset. I so to think the point is, I didn't write this earlier. There was a substantial influx of income during that year. There's an issue with the last minute tax treatment change, and so there were expressions at times of surprise. I know the government's point is you knew you made a lot of money. It shouldn't come as a surprise. My only concern is when I read this as a lawyer, it shouldn't have come as a surprise. That doesn't preclude Mr. Biden from saying, yes, it did. Your Honor's characterization is exactly right. They're saying it actually was a surprise in that year. You guys are okay with that? Yes, Your Honor. Okay, but you know you own tax money, right? Yes. And your business partner told you that no withholdings have been made. Yes, Your Honor, I believe that to be the case. All right, in the third paragraph, which is actually the second full paragraph, says on or about March 22nd, 2018, you received $1 million payment into your Allwaska bank payment account as payment for legal fees to Patrick Ho. Who is that payment from? Was that a law firm? Received from Patrick Ho, Your Honor. Mr. Ho himself? Yes. Were you doing legal work for him separate and apart from the law firm? Yes, Your Honor. Well, this wasn't through Boyce Schiller, Your Honor. Mr. Biden was engaged in an attorney. Right, so that's why I asked. You're doing work for him? My own law firm, not as counsel. So your own law firm as well? The defendant says, I think Ayahuasca PT acted as a law firm entity. Ew. Ew. So Hunter Biden, world's greatest lawyer, formed a company called Ayahuasca PT, and he thinks Ayahuasca PT acted as a law firm entity. Okay. I believe that to be a case, but I don't know that for a fact. How can the world's greatest lawyer not know whether or not Ayahuasca PT acted as a law firm entity? How can he not know that? He received $1 million, $1 million from this one guy for legal services. He is truly a wonderful lawyer. $1 million from one guy for legal services for a year. He truly must be a fantastic lawyer. Yet, somehow, the company that he founded and is the owner of and is his company, he is unsure whether or not it's a law firm entity, and he doesn't know that for a fact. Okay. Okay, the final paragraph on second page of the exhibit says you receive a little bit more than $2.6 million in business and consulting fees from a company you formed with the CEO of Chinese business conglomerate and UK energy company. And I guess originally I was asking if the addition to your money you've received from, if it was in addition to the money you received from the law firm, but I think we clarified earlier. Yes, Your Honor. So what I guess is I'm confused about, so is that $2.6 million that was in 2018? That's our understanding, Your Honor. But in the first paragraph of the exhibit for the work you did for the Ukrainian company and Chinese company in your domestic business, it was 2.1 million. Your Honor, I think this actually for this one, and again, we didn't write this, but we don't dispute its accuracy. I think it may summarize a chain of payments that was made over a couple of years. Your Honor, as I read that, the reference in the first paragraph is to income, and it's more than that. The language is more than $2.1 million in 2018. And by contrast, the paragraph Your Honor just pointed out, it's talking about fees that he generated at about 2.6 million. I think were expenses that were business expenses that would have been taken from those fees to get you a little lower income that's north of 2.1 million. Okay, in the first full paragraph of the third one, it says after numerous programs and trips to rehab, you got sober in May of 2019. Do you see that? Yes, Your Honor. When I asked you earlier, when you last used or were under the influence of a controlled substance or medication, you said June of 2019. What was it that you did in 2019? I was married in May of 2019, and that's my sobriety date. When I asked about you earlier, I was being conservative, Your Honor. I think that the date, to be technically and completely honest, from the day I got married until June 1st, I did have a drink or two. Okay, guys, here's a question for you. Here's a question for the chat. How many is one? How many is two? Here's a math question you didn't think you'd have to answer for you. Here's a question for the chat you didn't think you'd have to do. Can you define one? Can you define two? How many is one? How many is two? Please put your answers in chat. Okay. So I count my sobriety as the least in the program you attended from June the 1st. So that's why I did that. You're saying the program you attended. I thought, are you attending? No, a separate program that required anonymity, Your Honor. Okay, but I'm just trying to make sure that we don't. No, I'm saying that there are programs that I got involved in right now. I'm saying meetings I go to. The sobriety day is often quoted. He draws a distinction between treatment and a program. Okay. And it's not that. I appreciate that. Whether we call it treatment or something, you're doing something to support your sobriety. Is that correct? Yes, Your Honor. Okay. All right. Then that paragraph says you did not make preparations to actually file in 2018, individual or corporate income tax when it's due in 2019. Is that right? Okay, it was due according to this October 2019. Yes, Your Honor. And were you sober at the time? I was, Your Honor. But you didn't file your taxes. Yes, Your Honor. I was putting my life back together. It was a flood, an enormous amount of problems. And by the time I was able to find someone to be able to help me, I was already past the deadline, which I should not have gone past. But you had an accountant, so you did have someone to help you. All you had to do was literally sign the page. Okay. At the end of the paragraph, it says in 2020, during your process of you're putting together your 2017 and 2018 tax returns, you mischaracterized certain personal expenses as legitimate business expenses. What is that referencing? Your Honor, it may be better if I explain it because Mr. Biden is actually not that close to the facts. What? But he's the guy. What do you mean he's not close to the facts? What? Okay. Uh, all right. Uh, fine. In essence, it's a very compressed time frame. Mr. Biden was asked to identify for all those tax years that were being done from his credit cards and other bank accounts what's a business expense and what's a personal expense. He has to go through charts and mark them. And there are situations which he made an error with regard to marking business expenses or personal expenses. In several instances, most of them relate to one account, which is a business line of credit, which he and his accounts treat as business expenses, but he never reviewed the actual records for because the accountants couldn't get the records. Why? So if we concede that he made mistakes, erroneous mistakes in categorizing some of these expenses, and that's what it refers to. Uh-huh. Do you know the approximate amount of money in these mistakes? That's what the discussion of the dispute was. We see it as not minimizing, around $30,000 over the entirety of all the filings. I think the government thinks it's higher, but that's part of what we're going to shake out in sentencing. It's not massive amounts of money from perspectives of these tax returns. And this points out to, I think in the next sentence, during the same year these errors were made, Mr. Biden's accountants erroneously overreported his income by several $100,000. And so there are errors going both ways in that year. Some of these mistakes and mistakes by his accountant. So his accountants apparently are horribly incompetent. And so I just understand, are these things that he made mistakes and give them to his accountant, that they were corrected or made these mistakes, gave them to his accountant, and then those mistakes ended up being filed? It was the latter. The accountants didn't catch all the mistakes. That's okay. Hunter Biden is on the job, people. That is okay. Hunter Biden's on the job. The accountants may not have catched the mistakes, but never fear. Hunter Biden is here. Okay. And again, this was done after you're already sober? Yes, Your Honor. All right. In the next paragraph, there are more references to a self-assessed tax. Is that the same one we discussed previously, the amount of tax he determined he owed? Yes, Your Honor. And at the top of the last page, and those also guess the last page, or maybe in all those paragraphs, there's a reference to a third party who paid your tax liability. Is that the same person who paid off all the outstanding liability? Yes, Your Honor. I took out a loan from that individual. You took out a loan? Yes. Do you make payments on the loan? Not currently, Your Honor, but it's normal, typical loan with terms and a time frame. A loan. He took out a loan to pay his taxes. A loan. Okay. I mean, I guess someone really sees the best in Hunter Biden. This drugged up, 6-time failure of inpatient drug rehab who, since May 2019 or maybe June 2019, has not had a single drink or drug of any kind. This person apparently sees hope in Biden and is willing to extend him a loan. If any of you guys would like to give me a loan, you can send me a super chat. I promise to repay you someday. Okay, all right, let's talk about paragraph 9, the appellant waiver provision. Mr. Biden, your agreement contains an appellant waiver provision in paragraph 9. The waiver limits your ability to appeal your sentence. Have you discussed this waiver with your attorney? Yes, I have, Your Honor. Are you satisfied with the advice and counsel you received? Yes, Your Honor. Now, can I read the waiver to you if you'd like me to, or can you tell me what you're confident you understand? Do you want me to review it with it? I'm confident I understand it. Do you understand that it's broad waiver provision and leaves you with narrow appellate rights should you disagree with your conviction or sentence? Yes, Your Honor. And then it leaves you little ability to challenge your conviction or sentence? Yes, Your Honor. $5 from Fair Frozen 55. This is a small loan. Remember to pay it whenever you feel like it kisses. Aw, thank you. I will put that on my books with a notation that I own, that I have a liability for $5. Thank you very much. Do you understand it's unlikely the conditions that would allow you to appeal will occur, and likely you have no relief should you receive a sentence that's different than the one you anticipate? All right, I find the defendant has knowingly and voluntarily waived his rights. Now, as Mr. Wise said earlier, I want to talk to you a little bit about the sentencing process in federal court. It's not required in a misdemeanor case, but I'm going to ask the United States Probation Office to prepare a pre-sentencing investigation report to the court before sentencing. You and the government will have a chance to review and challenge the facts. Do you understand that? Yes. It's been my responsibility under the statute to impose a sentence that's sufficient, but not greater than necessary to provide punishment and afford deterrences. Under the current law, I have to follow a 3-step process. First, I have to consider the sentencing guidelines that have been calculated by the probation office and any objections to the guidelines. Then I have to rule on any motions for a departure from the guidelines and explain how those motions, if granted, would impact the guidelines. Dave said, from one IP goon to another, thank you, Kurt. Thank you, Dave. That's very nice. And thank you, EE Caroline, for the 99-cent emoji with a pile of poop with a face. That's kind. Thank you. And finally, you have to consider all the factors in the statute, including personal factors that would help me determine what the appropriate sentence is. And that sentence may, again, vary either upwards or downwards from the guidelines. The government has agreed not to oppose a sentence of probation, but it's important you understand that without reviewing the pre-sentence report, I cannot predict for you today whether I'll agree to that or not. Do you understand that? Yes, Your Honor. Do you also understand that parole has been abolished? And to the extent you were given any period of imprisonment, you would not be released on parole from imprisonment. The federal government abolished parole long ago. You can get good time credit, so you can get out early, but there is no parole in the federal system anymore. So that was abolished long ago. I want to say in the 70s, but I have to double check that date. Maybe it was more recent than that. Do you understand that if you're sentenced to a term of incarceration following a period of supervised release or period, if you're given a period of probation, you're found in violation of the conditions of your release or your probation that may be revoked, and you have to serve additional time in prison if you were imprisoned or you were given on probation that might have served time in prison? Yes, Your Honor. Do you understand your sentence may include a payment of fine or restitution and will include a mandatory special assessment for each offense? Yes, Your Honor. Have you discussed with your counsel what the sentencing guideline calculation might be for the offense to which you're pleading guilty? Yes, Your Honor. And do you understand that if I impose a sentence that's harsher or longer or more severe than the one you anticipate, you will still be bound by your plea and you'll not have the right to withdraw? Yes. All right. Now I want to talk to you about some of the rights you waive if you plead guilty. Do you understand that you have the right to plead not guilty to the offense, to persist in your plea of not guilty, and to have a trial by jury on the offense, during which you would also have the right to assistance of counsel and the right to see and hear all witnesses and have them cross-examined on your behalf? Yes, Your Honor. The standard of proof is beyond a reasonable doubt as the highest standard of proof in our justice system. If the government failed to establish your guilt by reasonable doubt, you'd be acquitted. Do you understand? Yes. Do you understand at trial you would have the right to, on your own part, to decline to testify or put on any evidence at all? And if you decide not to testify or put on any evidence, it could not be used against you? Yes. Do you understand if the case were to go to trial, it would be the government's burden to prove to a jury by reasonable doubt each of the elements of the charge, and the jury would have to unanimously agree as to your guilt? Yes. Do you further understand that by entering a plea of guilty, there will be no trial? You'll waive to give your right to a jury, as well as the right associated with a trial? Yes. I'm now going to ask the prosecutor to summarize what the government would be prepared to prove if it went to trial. Your Honor, I've read in its entirety the factual statements that would be prepared to prove. All right, do you want to tell me how that meets the essential elements? Yes, Your Honor. I mean, I can figure it out, but I think it's probably worthwhile you telling me. The first element is that the defendant has a duty to pay the tax. The defendant earns substantial income, as the factual statement points out. And we go with, as Your Honors point out, there are several places in the factual statements where identified he obviously earned, looking at the first paragraph, $2.3 million in 2017 and $2.1 million in 2018. Do you think it's too late for me to change my last name to Biden? Do you think it's too late? I could do that. I could change my last name to Biden. You think it's too late? The tax was not paid at the time required by law. Even when he received an extension, the tax was due in April of 2018 for calendar year 2017 and April of 2019 for calendar year 2018. And finally, the failure to pay was willful. And the plea agreement stacks of facts describe that despite the addiction issue, he's able to generate significant amounts of income and make financial decisions about how to spend that money. And those decisions do not include meeting his obligations to pay his taxes. All right, Mr. Biden, is there anything you wish to challenge or amend in the government's proof? No, Your Honor. Do you disagree? No, Your Honor. Mr. Clark, do you have any objections? I do not. All right. Now, at this point, I would normally ask Mr. Biden how he pleads, but we've already discussed the diversion agreement is out there in a felony case. It's cross-referenced in the memorandum of plea. The plea agreement is cross-referenced in the diversion agreement. So before you ask him how he pleads, I need to understand, well, ask him how he pleads or decide if I can accept the plea agreement. I need to understand the diversion agreement. So the felony gun charge here is a bit unusual. We don't usually make diversion agreements public. I don't usually see a diversion agreement as the parties up here have hinted. But in fact, you all did send it to me, and it's referenced in the agreement before me. So it's a bit unique in that I have a copy of the diversion agreement, and the diversion agreement contains what I view to be some non-standard terms like broad immunity and a term that invokes the court or involves the court as part of the agreement. So given all that, Mr. Wise, why don't you go ahead and summarize the terms of the diversion agreement, given the parties have agreed to make it public? So maybe we'll get to see a copy of this at some point. That'd be cool. Yes, Your Honor. Under the first Roman numeral 1, the parties to the diversion agreement are the United States of America by and through United States Attorney's Office for the District of Delaware and Hunter Biden. Roman 2 describes the terms and conditions of the agreement. Paragraph 1 provides that it's for a 2-year period, 24 months beginning in the date of approval of this agreement. It would be where the Chief Probation Officer, Mr. Bay, signs it unless there's a breach, as paragraphs 13 and 14. Yeah, B-Fish Biden isn't bad. I could change my name to B-Fish Biden. What do you think? Should I become B-Fish Biden? Well, Kurt, I didn't know that you wanted to be a B-Fish. I feel honored by your presence and your love for me. Well, B-Fish, it seems to me that you truly can make anything happen. And I mean, after all, you are a B-Fish. And so you are truly capable of some wonderful and great things. Well, thanks, Kurt. That seems, or should I say, B-Fish. Haha. Thanks, B-Fish, for, believing in me and seeing that I can be a wonderful thing. Yeah, you're definitely opening my mind to strange and exciting ideas, B-Fish. Well, thank you for being me. And if you want to be B-Fish Biden, I will stand with you. I'll stand by you. That's really nice, B-Fish. Thank you, Callie. You're welcome, B-Fish. Ah. All right. Paragraph 1 states that for a 2-year period, paragraph 4, 24 months beginning the date of the approval, would be where the Chief Probation Officer signs it unless there's a breach set forth in paragraphs 13 and 14. Paragraph 2 provides this 24-month period will be known as the diversion period. Paragraph 3 provides that Biden shall waive indictment in relation to the information filed with the gun case, in which charges him with 1 count of knowingly possessing a firearm while an unlawful user or a person addicted to controlled substances in violation of law. And the relevant year for the conduct is 2018. Paragraph 4 provides that if Biden complies with his obligations under the agreement, thank you very much, John, for celebrating 9 months of membership, then the United States, within 30 days after expiration of the diversion period, will file a motion with the court seeking dismissal. Paragraph 5, Biden agrees that the United States has probable cause to bring the charge and the information, and the charge is not frivolous or made in bad faith. He also agrees at a future time, should the United States should move to dismiss the information pursuant to the agreement, he will not be a prevailing party with regards to the information. It waives any possible claims to attorney fees or litigation expenses arising out of the investigation or prosecution. Paragraph 6 provides that in light of the fact that Biden has accepted responsibility for his actions, referred to in the statement of facts as attachment A to this agreement, and taking into consideration Biden's candid acknowledgement of his historical drug use, as well as current sobriety, and consideration for other terms of the agreement, the United States shall divert this matter in a manner set forth in the agreement, pursuant to terms and conditions set forth. Paragraph 7 provides that Biden agrees to waive all defenses based on statute of limitations with respect to charges in the information and any other federal firearm charges that could be brought with respect to the conduct set forth in a statement of fact. And he agrees that the applicable statute of limitations period for any charge arising under the firearms purchase shall be told during the diversion period. He agrees not to assert any speedy trial right under the Sixth Amendment or federal rules or any locale here in the District of Delaware. Paragraph 8 provides that it's the intent of the agreement for Biden to agree to be subject to the jurisdiction and venue of the United States District Court for the District of Delaware with respect to the charge set forth in the information and for any federal charges arising out of the firearm purchase set forth in the statement of facts. Paragraph 9 and its subparagraphs are commitments, undertakings of Biden that include not purchasing, possessing, attempting to purchase firearms as the term is defined in relevant statute during the diversion period, consent to permanent entry in the NICS system such that he'll be denied NICS if he attempts to legally purchase another firearm. So he can't ever buy a gun again. That's very sad. And then paragraph C, I'm not going to read the entire paragraph, but it's a provision that the gun in question is forfeited to the United States. Starting at paragraph 10, the court. Could I ask you to pause for 1 second? I forgot my glasses. I'm going to ask someone in the back to get my glasses, but I didn't want her to open the door and freak people out. All right, apologies, go ahead. Starting in paragraph 10, or paragraph 10 and subparagraphs are additional conditions applicable to the diversion period, and these include that Biden is subject to supervision as directed by United States Probation and Pretrial Services, that he continue to actively seek employment, they refrain from unlawfully possessing a controlled substance, they refrain from using alcohol, they submit to substance abuse testing and participate in substance abuse testing as directed by the United States Probation and Pretrial Services Office in this district. They submit to fingerprinting by the FBI and describes what will be done with those fingerprints and how will be preserved for a time. That he communicate in writing all international travel plans or provide documentation if requested to probation and pretrial, and he not commit any violation of federal, state, or local law. Paragraph 11. In paragraph 11, Biden acknowledges and agrees to statements in attachment A and agrees they're truthful and accurate. Paragraph 12, Biden agrees that neither he nor anyone else's direction will make any statement in litigation or otherwise repudiating or contradiction the statement of fact. If Biden believes the contradictory statement has been made and it contains a breach, then they may seek a determination. So you can't go out and deny this publicly. You can't go out and say, well, that's bullshit. So starting in paragraph 13, it lays out the procedure if there's a breach. Biden agrees that knowing failure to abide by the terms shall constitute breach. If the United States believes there's been a breach, it may seek a determination by a United States District Judge for a District of Delaware with responsibility for supervision. Upon notice to Biden, they may seek a determination on preponderance of the evidence presented to such district judge. Biden shall have the right to present evidence to rebut. If after the process, the judge overseeing the process makes a determination that Biden constituted a knowing breach of this agreement, the United States may elect from two remedies as specified in the agreement. Remedy 1, which is a sub of A, paragraph 14, is the United States may give Biden a specific period of time in which to remedy the breach. If the United States determines that Biden has failed to remedy the breach during the time period, the United States may elect Remedy 2. Remedy 2 is the United States may prosecute Biden for any federal crime violation which the United States has knowledge, including crimes linked to conduct set forth in facts, attachment A, and includes obstruction of justice. Any such prosecution is not time barred by statute of limitations by the date of the agreement, notwithstanding the statute of limitations between signing and commencement of the prosecution. And finally, the United States is not required to offer Remedy 1 before proceeding to Remedy 2 if in its determination the nature and breach warrants the termination. Paragraph 15 is the agreement not to prosecute. The language, United States agrees to not criminally prosecute Biden outside the terms of this agreement for any federal crimes encompassed by the statement of facts, and the statement of facts attached to the Exhibit 1. This agreement does not provide any protection against prosecution for further conduct by Biden or any of his affiliated businesses because, we're not going to give you immunity for things that haven't happened yet. Obviously, this paragraph has been orally modified by counsel for Biden, and I'm not going to attempt to paraphrase it. I don't want to make the record muddy. Statement by counsel is obviously, as Your Honor acknowledged, a modification of this provision we believe to be binding. Paragraph 16, starting in paragraph 16, there are general terms and conditions. The parties consent to public disclosure and publicly filed. The parties stipulate and agree the conduct set forth does not constitute relevant conduct for the offense. To tax offenses, which Your Honor has identified, the firearms is not relevant conduct for the tax charge. They are completely independent charges, which makes sense. Paragraph 18 may be executed in counterparts, each of which constitutes an original. So it could be that, I sign one version of it and you sign a different version, and they're both the original, is what that means, right? Or, if we both sign one and then send the other and we both sign it, they're both originals. That's what that means. And paragraph 19 is the incorporation agreement that says that this is the final agreement. The court, any corrections you want to make? No. The court, the information charges Biden with violation of law. Does anyone have any concerns about the constitutionality of that charge in light of the recent Third Circuit case? Okay, that's a good question. So, from first principles, is this constitutional? I guess that's an interesting question. Should we? So, from first principles, is this a valid law? So, it is prohibiting someone who is an unlawful user of or habitually addicted to any controlled substances from possessing a firearm. So, is that historically valid under the Second Amendment? Probably not. I mean, the idea of controlled substances didn't really come around until, I mean, the earliest you could get to was like the Food Purity Act. And what was that, like 1910? 1906. That was close. So the idea of drugs being regulated, like in any sense, doesn't really go back before 1906, really. And even then, it was dealing with food purity, not drug purity. So there's no historical analog for controlled substances. Or at least not directly. Hmm. So is it legal under Bruin? Is a restriction that prevents a habitual user or a user or an addict of a controlled substance, is that constitutional? Hmm. I don't know. I'm not 100% sure it is, to be honest. I'm not 100% sure it is constitutional under Bruin. Hmm. No, Your Honor. Your Honor, I note that what's one of the reasons the parties think they're disposition we are. We don't waive layer prosecution challenges like that. I completely understand that. That's kind of why I was asking the government the question. I thought the Supreme Court already ruled on it. Not on this, they didn't. No. Otherwise, I wouldn't be asking the question. So of 2019, so 922G3, which makes it unlawful for a drug user addict to possess a gun, were found by some court to be unconstitutional. What happens to the diversion program? Your Honor, the diversion agreement is a contract between the parties, so in effect until it's either breached or determination period. The analysis, I believe, has to do with impairment and firearms. It can apply to mental illness. Well, that's a separate provision, and even then, you're adjudicated. You have to be adjudicated mentally infirm, which probably there is more historical analog. I don't know that you can necessarily come up with a per se rule that anyone who's habitually addicted is per se mentally infirm. I'm not sure if that makes sense. Well, thank you for the $5 super chat. I can tell you our intention would be to abide by the agreement, only raise such constitutional questions, determining at such a time that someone tried to bring any charges on this. Otherwise, it's an agreement. We're going to honor the agreement. I've had one or two cases involving a person struggling with addiction who bought a gun. We usually see a felony charge for a false statement. The defendant has admitted the statement was false, but wasn't charged. Again, I'm not trying to get into the purview of the prosecutor. I understand separation of powers. It's your discretion. But I want to bring, it has to do with controlled substances and impairment. I don't think that quite works. I don't think that quite works. To say that someone can't use a gun while they're impaired, maybe, but I don't think you can say that just because someone is a habitual user of a drug that they are perpetually legally impaired. I'm not sure that that works. Yeah. Hmm. I'm not trying to get into the purview of the prosecutor. I understand separation of powers. It's your discretion, but I want to ask, does the government have any concern about not bringing the false statement charge in live discussion of G3 and the constitutionality of the charge? No, Your Honor. Paragraph 7 says the statute of limitations is waived. Can you tell me what the statute of limitations being waived on a charge of false statement if the diversion agreement were in place? Where it would run, Your Honor? I understand it's told by the agreement. I have concerns about the agreement, which is why I'm asking these questions. So if the agreement weren't there, it'd be October 2023. October the 12th, 2023. All right, thank you. Now, I've reviewed the case law and I've reviewed the statute, and I understand that the decision offered the defendant, any defendant, a pretrial diversion rests squarely with the prosecutor. And consistent with that, you've all told me repeatedly there's a separate agreement. There's no place for me to sign off on it. I think as mentioned earlier, usually I don't see those agreements. But you all did send it to me, and we've discussed. Seems like some of it could be relevant to the plea. One provision in particular stands out to me, and that's paragraph 14. The paragraph says that if the United States believes there's a knowing material breach of the agreement, it may seek a determination by the United States District Judge for a District of Delaware with responsibility for supervision of the agreement. It then goes on to say that if I do find a breach, the government can either give the defendant time to remedy the breach or prosecute him for the crimes. Do I have that understanding correct? That's my understanding. So you can tell me what's complicated by that, how it would work. So obviously the diversion agreement covers offenses relating to firearms. 499 from Hamilton. Hi, Kurt. Wanted to thank and support your channel and the mods and chat as well. Wishing everyone a terrific weekend. Well, thank you, Hamilton. And it's always a good time to remember to thank our moderators who do fantastic work. Thank you, moderators, for making this channel a nice place. We appreciate civility here in the chat. We appreciate that you help to instill a positive atmosphere that everyone can feel like they're welcome to be here. It is a good thing. Your Honor, I think Your Honor may be asking about the functionality of her involvement, and the concept was along the lines of a VOSR, where the situation is brought to the court, and the court would be making a factual determination in the first instance if there's a violation of supervised. I mean, diversion is not supervised release, but in some senses it can be. And so the idea the court would determine whether or not it's a violation, and the government would move on to remedy. First, it got my attention because you keep telling me I have no role. I shouldn't be reading this thing. I shouldn't be concerned about what's in these provisions. But you've agreed that I will do that, but you didn't ask me to sign off on it. So do you have any precedent for that? That's nice, right? So it's like, this is not something that binds me, but you're putting a role on me that I'm not agreeing to, that isn't required by statute. Nice note from the judge. That's sharp. Bonus point. As I read it, tell me if you're reading this correctly, that under the agreement, as you all have drafted, the only way charges could ever be brought is if I have the hearing that you've all agreed that I have, right? Yes. So if I don't have a hearing or make a finding, no criminal charge can be pursued for the gun charge or any other federal charge within the scope of the agreement. I believe that's right, Your Honor. So is there some requirement that you have that I make the finding that you all agree to that I would without asking? Is there a requirement that says I have to make the finding? No. And you don't have any precedent for it? No. Right? You're asking me to do something. I'm not agreeing to it. There's no statute that says I do. There's no precedent that says I do. Why am I here? Right? This is good stuff. Do you have any authority that any court has ever accepted that? No, Your Honor. This was crafted to suit the facts and circumstances. I'm concerned that this provision makes me a gatekeeper to criminal charges and puts me in the middle of a decision as to whether to bring a charge. We've already talked about separation of powers and the choice as to where the charge is not. That's the executive branch, not the judicial branch. So is this even constitutional? I believe it is, Your Honor, because when the structure makes clear is Your Honor is just finding facts. But no charges, usually in these agreements, right, Mr. Clark? The prosecutor says we think he breached. And I don't mean to point it out. I'm not saying you're going to breach. I understand. We're doing a hypothetical. I understand the question. The prosecutor says there's a breach, Judge. We've got to move forward on the information. You then come forward and you're like, Judge, he didn't breach. Review this. Okay, so that's the standard. The government has. The executive branch has already made a determination. We're going to proceed with the charges. Now, the government cannot make the decision to proceed with the charges absent involving the court. Nice. That's sharp. It's an interesting way of framing that. That's very, very nice. This judge is intelligent. I appreciate his observation. Respectfully, Your Honor, I don't think it's structured that way, and I do think the way it's structured may get past some of your concern. What it is not that the government has decided to bring charges. It's the government believes there's a breach. In paragraph 14, the government brings the breach to Your Honor and says we need a determination whether there is a breach. So it's not a question that we decide what to opt into. We decide what to do. We want you, it's Your Honor. We believe there's a factual dispute between the parties, not the breach. We'd like you to make a factual determination. Why can't you do that in the normal way? As I read this, the government has no discretion to bring charges. It believes the breach has occurred unless I opine. Can we approach and discuss one issue with Your Honor? You mean because it's confidential? Yeah. Okay, you're going to have to make a showing as to why. As I understand, once we're in court in the Third Circuit, it's essentially strict scrutiny. Can you explain to me why this is something that goes onto the record? The court is busting balls, right? The court is busting balls. It relates to plea discussions between the parties generally, which aren't discussed publicly. I'll allow you to we'll have a discussion on the sealed portion, but you're going to have to convince me it needs to be maintained as sealed, okay? Because I can't, it's hard for me to say in the abstract if you're saying it's a plea discussion. So the judge is like, we can do it, but I'm not guaranteeing it's going to say sealed. Because, this is strict scrutiny. And, we don't go off the record unless, we don't go off the record, and yeah. Your Honor, let me try to handle it separately. There is desire because of there being, as Your Honor has seen, a tremendous amount of political drag with this defendant. The normal mechanism might have taken place would be the protection of the court, non-discretion to bring a charge, but in finding a breach, and so that wouldn't be something that would become more politicized, but rather be something the parties could rely on, something we consider neutral arbiter to determine the breach, not the charge. I understand. Look, I knew why you brought it, okay? I can see why you'd want that provision here, but I don't. You're putting me, the government, the executive branch has discretion to bring the charge. Here, the government does not have discretion to pursue the charge or any other charge unless you include this court. It seems like it's getting outside my lane in terms of what I'm allowed to do. And thus, I have concerns about the constitutionality of this provision. This gives me concerns about the constitutionality of the agreement because there doesn't seem to be separate severability. And it gives me concerns about whether the defendant has the protection from prosecution he thinks he's getting if this agreement turns out not to be worth the paper it's written on. So it doesn't have severability provisions. So it's a she, not a he. Thank you for the correction. I apologize for if I apologize for the slip of the tongue. This judge is very smart. She is very smart. No disrespect intended. My concern is, and part of what I have to do is knowing involuntary. I can't let him. I'm not convinced this plea under subsection B, but even if it is, and all I have to say is knowing and voluntary. I can't let him plead to something if he thinks his protection is he doesn't. Absolutely, Your Honor. I think the analogy to a VOSR is not a bad analogy. The government comes to court and says, Your Honor, we believe there's been a violation of supervised release. Unless you, judge, make a factual finding that's happened, we can't do what we normally do with regards to the defendant, right? And again, it's the fact and then there's discretion, right? And so here it's very analogous to that process, which is not a violation of separation of powers. I understand what Your Honor is saying. I think I might need a bit more on this because it's confusing to me, but or concerns I should say is confusing. Let me ask you this. If this provision violates the Constitution, what happens to the diversion agreement? If that provision violates the Constitution, the diversion, first of all, I'm not aware of a manner in which we could challenge the diversion agreement. But if it did, I'd say that if it's unconstitutional, right? The way I'm seeing it is the government decides not to be politicized. The government decides we're going to bring a charge, and you say no, that's prohibited by a diversion agreement. And the government says the diversion agreement is unconstitutional. You don't have the protection of it. So I'm not going to voice my concerns when I think there are, you're telling me you're not going to challenge it. It really doesn't. No, I'm saying that, Your Honor, under the circumstances, we'd have contractual dispute about the contract between the government and us, and it get litigated by any other contractual dispute would get litigated. That's what it is. But what if it's unconstitutional? What happens to the diversion agreement? I think it's valid, but for this provision. Is there a severability provision? There isn't. Uh-oh. Uh-oh. VOSR is violation of supervised release. VOSR is violation of supervised release. So it's a violation of your bail. There isn't a severability provision, but there's nothing that says it's a unitary contract either. It's kind of half and half. What? It's half and half? What? There's no merger clause or severability clause, so it's a toss-up. What are you talking about right now? What are you talking about right now? It's a toss-up? What words are you saying, man? So if I'm to say I'm not going to do what's requested, what have you all agreed to that I'm going to do? What happens to the diversion agreement? If you're saying it right now in a binding manner, I'm just asking. I'm not making a finding. I'm asking you because I'm trying to exercise due deliberation and consideration. Make sure we don't make a misstep. So, Mr. Wise, I'm saying I'm not doing it. Your contract has impossibility in there because there's nothing that can happen. I understand Mr. Clark might say it's fine, Your Honor. But government, what happens if it says I'm not going to do that? You can agree I'm not going to do it, but I'm not. So negotiating these terms, we obviously agreed to, as Your Honor pointed out, the executive branch has authority to bring these charges. We'd agreed to a limitation, if you will, that's predicated on the court taking certain action. If the court declines to take an action contemplated by the agreement, we'd have to examine whether there's other ways to seek enforcement. And there is a way to modify the agreement, obviously, between the parties, Your Honor. If so, by written modification, we could modify the provision if Your Honor said I won't participate. All right. So what are you talking about? I'm saying that if Your Honor said I've determined this is improper, I'm not going to participate. We could work on a provision, paragraph 19, which says we can modify or add to the agreement with written consent of the parties and would come up with alternative dispute resolution system. I personally, Your Honor, again, I don't mean to hang everything on the VOSR analogy. I've done many of them in my life. I don't think it's unconstitutional. I think it's a very fair question from the court. I don't think it is. But I think if the court were to determine it's not appropriate, we would modify the contract and determine on another dispute resolution. The analogy I'd offer, Your Honor, VOSR statutory framework, is many United States attorneys' offices practice for around the country have proffered agreements for Queen for a Day agreements, where a defendant, a witness, a target will sit down, make certain statements pursuant to agreement. And some of those agreements have provision that in the event the government believes the breach that they lied, they'll go to a judicial officer for determination. And if that's the case, the agreement is determined void. The charges, for instance, 101 making a false statement to law enforcement can be brought. All right. Queen for a Day. What a great phrase of law that you don't get to see very often. So yeah, this is actually a thing, right? So Queen for a Day is basically a limited grant of immunity. It's a limited grant of immunity that lasts as long as the conversation lasts. That's what Queen for a Day is, right? So the government wants you to, right? You have a right not to testify against yourself. You have a right to prevent testimony against yourself, right? So if the government wants you to talk to them, they could grant you immunity, right? And that would be like a permanent thing. But there's also another option. Well, it's Queen for a Day. And it's used a lot more frequently as plea negotiations or other sort of it's used to give the defendant the ability to reveal information to the prosecution without it being used against you. So basically, it's a grant of immunity for as long as the conversation lasts, right? So you sit down with the prosecutor, and everything you say can and will not be used against you in the court of law. Everything you say cannot and will not be used against you in the court of law. So that's Queen for a Day. But what they're pointing out here is that those agreements come with some terms. For example, not to lie, which, you don't have a right to lie. You don't have a right to lie when you're under oath either, right? If you have immunity. So immunity doesn't allow you to lie, right? So if they catch you in a lie, they can use it against you. So that's bad times, right? Because you've given the government everything they need to convict you in your statement. And if you lie, they can use the entire thing against you. Plus, they can charge you with lying to the federal government. So it's a bad time. So don't lie. Fast Group says, why does the government have the right to lie? Police have the right to lie as part of an investigation tool. The DOJ and prosecutors don't have the right to lie. We can get into how true that is in the real world or not, but we'll just note the law. How about that? Police are allowed to lie as an investigation tool. Attorneys are not allowed to lie. So the government attorneys can't lie. So, yeah. So, and why are they allowed to lie as an investigation tactic? I suppose because there's no prejudice to you in some way. Yeah. Yeah, we could talk about how true that is in the real world, but let's press on. Anyways, so we read all that. So I think they're similar in their agreements, unlike VOSR, that are not governed by elaborate statutory schemes. So some of this is defined by statute, by the way. So, yeah. The senators from each state nominate the judge? Really? Wow, that's novel information to me. I didn't know that. I didn't know the senators from each state nominate the judge. That's incredibly interesting information, just me. Wow, that's I didn't know that there's been a 20th amendment to the Constitution that passed in the last, 10 minutes. I guess I'm not up on my up in my latest constitutional developments. Thank you for that late breaking news. So it's similar, and agreements like VOSR are not governed by elaborate statutory schemes. They're contracts between the United States and individuals, but contemplates a role for judicial officers that affects the ability of government to bring charges. I take your point to an analogy to the VOSR, but I was asked if there's any precedent for this. I was told no. I was asked if there's any authority for this. I was told no. And I get the analogy, but you don't think that I can on the fly make the analogy you're asking me to make, or even, you're telling me that this is, so that's appropriate. So I'm not sure. I'm not sure what to do with that. It may be that you're correct, but that's an appropriate analogy, but maybe that you're not. May I propose something, Your Honor? You don't have to. There's no action again. No to. I know you don't necessarily want to hear this all the time, that you can take with a regular diversion agreement. Can I propose that Your Honor take time with regard to this provision? Inform the parties, and if you find the provisions improper, we can brief it for you. I'll commit with the government and we'll work under paragraph 19 to implement some procedure. But again, I don't think that needs to hold up today's disposition. The problem I have is I'm not just sure that it doesn't. Again, you're all telling me just rubber stamp the agreement, Your Honor, because all we're doing is recommending a plea. But it seems like the argument you're making is form over substance. What's funny to me is you put me right smack in the middle of a diversion agreement I should have no role in. You plot me right in here. And then on the thing that I normally have the ability to sign off on a look in the context of the plea agreement, you take it out and you say, Your Honor, don't pay any attention to that provision, not to prosecute, because we put in an agreement that's beyond your ability. So this is what I'm going to do. These agreements are not straightforward and they contain some atypical provisions. I'm not criticizing you for coming up with them. I think you've worked hard to come up with creative ways to deal with this, but I'm not in a position where I can decide to accept or reject the plea agreement, so I need to defer it. First, I don't know what rule this actually falls under. I'm not convinced this is actually a plea under subsection B, which is you suggesting me rubber stamping the plea if it's a knowing plea. But even if it were, I have testimony under oath from both the defendant is concerned about ensuring his immunity from additional charges, and also, he doesn't need that in terms of the plea agreement. So I think about that. Additionally, I need some understanding as to why this plea under B and my concern about the form over substance of the agreement not to prosecute is valid, or why I should bring this. Okay. So let's talk about moving the goalposts a little bit. Just Me initially said the senators from each state nominate the judge. And then moving the goalposts, Just Me says states can elect or appoint judges according to their state constitution. These are not the same claim. These are not the same claim. Okay. I just want to note. So I'd like some additional briefing on why subsection B is the appropriate section. And if we're to determine this actual is a plea under subsection A, it'd be helpful to me to have your views on what it is that makes a plea acceptable. Because I'm not saying it's not, but nobody seems to really have given me that what I would need if it were determined that as I read as a whole. I need to think about what's really in front of me, so I need that. And then as you offered, Mr. Clark, you guys can go back and work on whether or not you can take out the provision and come with something else that's not acceptable. And while you do that, you might, though I'm not trying to tell you how to negotiate a diversion agreement, you might fix the one paragraph that you have orally modified today. I'd like to understand why that provision, if you want to go forward, is appropriate. Why I'm not doing something that gets me outside my lane in terms of my branch of government if I were doing what's being requested. Does that make sense? That makes sense, Your Honor. I think the party's been very eager to resolve this matter. It's been pending for an extended period of time. It hasn't been pending for that long a period of time, and I know when you guys first called, you said that you'd send me the agreement on Tuesday or Thursday. You want to have a hearing within a few days. I couldn't accommodate that schedule, but the fact is, this is under our normal course of timing. And so I certainly understand why you want to get this resolved. But I'm not in a position where I can do that now. So if you guys want to tell me what you're thinking, you can get the papers I'm asking for. Your Honor, what I'd anticipate is we need, in order from transcripts to today's proceedings, to address some of the issues you have raised to make sure we're precisely addressing what you're asking us to. And I so think building up a little in time and getting the transcript, a reasonable amount of time after that submits at least 14 days. Fine with us, Your Honor. I also say, Your Honor, that we're not asking the court to rubber stamp anything. It certainly sounds like it. Tell me again why you think my role is under a plea of B. Cute. It's not what I think the court's role. I agree. I read the rule. The rule says I couldn't accept or reject. You're saying it's not a rubber stamp. So what is it I do? You don't take an action on a plea agreement. What Rule 11C says is that for Rule B, the court must advise the defendant. The defendant has no right to withdraw the plea. The court does not follow the recommendation request. So the rule does not contemplate the court taking any position on the agreement. If it's B, rather requires the court to give that advisement, and that extends to the court rule. This has been briefed in another circuit, but not our circuit, certainly not that. I certainly understand that. If it's a plea under subsection B, I'm not going to just agree with you as it limits my role. My problem is I'm not, as I'm sure. I need to understand the propriety. It may very well be that this is appropriate. But as I said, it did catch my attention. You threw me in there, Judge. You're the gatekeeper, and then you take me out of the other aspects. You throw me in the diversion agreement, and then you take me out in the memorandum plea agreement. So I cannot accept the plea agreement today. I mean, based on what you said, Mr. Wise, Mr. Clark, if you want, I can accept the guilty plea while I defer my decision on the plea agreement, which the Supreme Court said is appropriate in the Hyde case. If your client wants to plead guilty pending my determination on the plea agreement, how'd you like to plea without a plea agreement in place? That's good shit. We were pleading guilty pursuant to the plea, Your Honor, so that'd not be something we would do. Does that mean I need to take a plea of not guilty? I believe so, Your Honor. All right, so Mr. Biden, I know you want to get this over with, and I'm sorry, but I do want to make sure I'm careful in my view of this. So I do need some information. Part of that is making sure your plea gets you what you think it is. And part of this is making sure I do justice as I'm required to do in this court. So I need some additional information. I'm not going to say I'm going to reject the plea. I'm not saying I'm going to accept the plea agreement. I need more information. So at this point, I'm just going to ask you, without the plea agreement, without me saying that I would accept the plea agreement, how do you plead to the charges? Not guilty, Your Honor. Thank you. And so I look forward to the party submissions. And after we've had a chance to review those, we'll either issue the order as to what we're planning to do with the plea, or we'll have a status conference to get back here. Do we need anything else? I know we've talked about how we're on the clock now. Can we exclude the time, given that it gives me some time to look at these for 30 days or not? I imagine the court can exclude the time for briefing. Yeah. We agree, Your Honor. So we'll do that. And after we see, we'll get back and look to you. Mr. Biden, I just need you to stick around for a few minutes after we adjourn. I need you. My deputy is going to ask you to sign a release order that we talked about. I need you to go downstairs to the marshals and processing and catch up with probation. All right? Defendant says, yes, Your Honor. Anything else we need to talk about? On behalf of the United States, no, Your Honor, and thank you. And thus ends the transcript. Well, my friends, this has been a very lengthy and very interesting read. And I have to say, I am impressed by the judge. And I apologize for calling the judge he earlier. That was mean. That was mean. I should have paid more attention on the cover page because it gives the name of the judge, Marlene Norica. I should have given more. Yeah. So I should have given more hair. And who is Marlene? Marlene Norica. Oh, she's a young girl too. Oh no, she's 57. She's not that young, but she's looking good. She looks nice. She looks good. United States District Judge for the District of Delaware. She earned her Bachelor of Science from Lehigh University, Master of Arts in Biology from Columbia, Juris Doctor, Magna Cum Laude from Pittsburgh. She inducted into the Order of Coif. Ooh, fancy, fancy. We didn't have that at my law school. Not that I would have been eligible for it anyway, but that's okay. So she graduated in the top 10% of her class. That's what that means. She began her legal career as Associate Morse, Nicholas, Arsh, and Tunnel in Delaware upon graduation. She served for 25 years and counsel in 500 cases while specializing in patent law. Girl, a woman after my own heart, because she has a Bachelor of Science. It doesn't say what kind, though. So, all right. So she's a patent lawyer and representing parties in cases involving biotechnology, chemistry, consumer products, computer science, medical devices, and pharmaceuticals. She worked at Morris, Nicholas, Arsh, and Tunnel until she became a judge. Very, very cool. Let's see if I can find out what her degree was in exactly. Which science it was. That'd be cool. Lehigh University. Let's see. What is your bachelor's in exactly? Biology. A biology degree. Very, very cool. Very, very cool. Which isn't too bad. I can do a little bit of biology. Chemistry is the one I really struggle in. Chemistry is the science I struggle in by far. I don't understand chemistry. I can't balance an equation to save my life. Physics is my strongest. Biology I am okay in. Chemistry is a total disaster area. Don't ask me to do chemistry. Um, 10 gift memberships from Jessica Ten Hog, 20 gift memberships from Jennifer. Admiral Nelson's been a member for 7 months. Thank you for hitting that beautiful, beautiful join button. Super Iron Bob gave $2 saying I'm willing to be paid to believe it. Batman's Pet Goldfish says, as Jenner's pointed out, I'm willing to believe that 2019 is the last time he remembers being sober. John Koyman gave a pledge of $2,000 for the Biden Painting Fund. Thank you very much. New York Renal MD is a member for 18 months. Tina in the World is a member became a member by hitting that beautiful, beautiful join button. I love Adblock said, which bind are you going to hang in your room, which we were talking about paintings. Jason Lazat said, thank you, Kurt, for helping us understand these confusing legal concepts. Your videos are top notch. Jennifer gifted 5 gift memberships. Twisted Tragedy is a member for 12 months. Thank you for hitting the beautiful join button. Twisted Tragedy gifted 10 gift memberships. DS has been a member for 10 months. Thank you for hitting the beautiful join button. Fairy Frozen 55 said, this is a small loan. Remember to pay it when you feel like kisses for $5. EE Caroline gifted a poop emoji for 99 cents. Dave for $20 said, from one IP goon to another, thank you, Kurt. John Markiv has been a member for 9 months. Thank you for hitting the beautiful, beautiful join button. New York Renal MD said, this analysis, I believe, has to do with impairment of firearms and comply to mental illness. Renal is kidneys, right? You're a kidney doctor? Do you have extra kidneys? Kidneys are good. I like kidneys. My kidney does lots of nice things for me. Hamilton gives $4.99. Said, hi, Kurt. I want to thank and support your channel and the mods and chat as well. Wishing everyone a terrific weekend. Generous gifted 10 gift memberships. Thank you very, very much. And let's see what else we had. $2 from John Coleman said, B-Fish shall hereby be named Plea be the B-Fish. Carrie Berry Mom became a member. Thank you very much for hitting a beautiful, beautiful joint one. Nephrology. Nephrology. Branch of medicine that deals with kidneys. Okay. Well, renal is relating to the kidneys. So they have 2 different names for kidneys. They got renal and nephrology. That's too many names for the kidneys. How many names for the kidneys do we need? I already know renal, and now they want to teach me nephrology. This is too many terms, man. Pick one. You can't have 2. Nephrons are the structures within the kidneys. Oh, they have a special name for them. They call them nephrons. Fine. Kidney disease, kidney Yep. Renal is the system. Nephrology is specific to the kidneys. Is that true? Renology does not fall off the tongue, roll off the tongue? I don't know about that. Rolls off the tongue as well as nephrology does. Sounds too much like neurology. I remember Bio 101. I don't remember the particular substructure of the kidney. I also don't remember what's called nephrology. I'm like, I remember the kidney. I remember the kidney bone is connected to the liver bone. And I think we're going to sign off for now. So I think I'm going to try to go to the gym. Will I be going on Friday Night Frenzy? I don't think I will be going on Friday Night Frenzy. I think I might sit this one out. I've come very many weeks in a row. I might sit this one out and just listen because I'm a little tired and I've been streaming and I'm tired and I want a break. I think I might sit this one out. So I might, yeah, I may or may not show up, but probably not. I'm going to sit out. Science is cool. Science is badass. Science is cool. Biology, I can understand. You'd have to like re-educate me on some of the stuff, but biology, I can fundamentally understand. You know, chemistry is like, and physics is better. Physics is best. Yeah, science kicks ass. I'm going to sign off for now while I remain borderline coherent. I've been Uncivil Law until later, my friends. I hope all's well. Cheers, my friends, and goodbye.